Hey, please. Look, an urgent matter already filed on first, my lord. Can it be tomorrow, my lord?
What is the issue?
In fact, the no confidence motion is lost. Now the authorities, my lord, are trying to tinker with the consequences, and they are telling, my lord,
Panchayat.
no, my lord, municipal board, and
Okay.
they are telling that the private respondents will take oaths tomorrow, my lord. My lord, this is absolutely without jurisdiction, my lord. Once motion is lost, my lord.
Motion lost in a meeting.
Yes, my lord, we are the chairman and vice chairman. Now the private respondents are sought to be, my lord, given the chair.
So there was a no confidence motion against you.
Yes, my lord.
That motion was considered in a meeting.
My lord.
And
It's a
thereafter
meeting,
that there is a resolution that the no confidence motion is lost.
lost.
If a no confidence motion is lost,
Yes.
then the consequence in the Municipal Act,
We have to continue, my lord.
you have to continue.
Yes.
There is no fresh.
No, my lord.
Is there a bar that it can come like in Panchayat that 6 months, 7
No,
months?
no, my lord, no.
It's not there.
No, no, my lord.
It can come on the next day also. Whether
Yes.
there is any fresh.
No, my lord, no requisition. But what is, my lord, what has happened? Authorities are trying to tinker with the consequence. They are, my lord, now taking, my lord, the law in their own hands, my lord. They are saying, my lord.
What is the reason given?
My lord, in fact, what has happened, the deputy commissioner, my lord, has sent the resolution. No reason given. Resolution has been sent and saying that you take an action on that. And now we are told that by tomorrow or by Monday, my lord, the private respondents will, my lord, take oath. This is absolutely, my lord, it has not happened earlier.
Okay.
Deeply obliged, my lord.
My lord, I want to make it urgent.
What is the urgency?
I participated in the tender. There one more bidder. Not rejected, my lord. I was
Non-responsive.
technically qualified. Term was not, my lord. Now they have retendering the tender that process. For I wanted to tomorrow.
Yeah, please, Lord. My lord, only item number 3, my lord, part of matter today, my lord. My lord, can it be on Tuesday or Thursday, my lord? Because
Why?
already I have a part of matter in court number 7.
You come back at 2. We'll have it at 2. We are not keeping it.
And 4 item, my lord, it will take time, my lord.
Which court?
Court number 7, part of matter, my lord. That is why, my lord.
This is also a part of matter.
That's true, my lord. But so I pray.
So this is not important.
For accommodation. No, Lord's is accommodation, my lord, only. When this
We are
Tuesday,
keeping it. If you can come back in the day, we'll adjourn it. If you can't come back in the day, we'll adjourn it. I'm here. After 2 also. Make it. See if you are free at 2, come back.
Only my prayer.
Mr. Chetri, if that matter is continuing for the whole day, I'll not dismiss it. I'll put it in another day. If it is over, come back.
Because of this case, my lord, I could not prepare this case. That was the problem.
For Mr. Chetri, this case is required to be prepared.
That's true, my lord, but something has to be placed before Lord's be. Obligement.
On the prayer of Mr. B. Chetri, Lanark Council for the petitioner, who submits that in view of a partnered matter in another court today, he is not in a position to argue the matter, the present matter today. So, accordingly, registry to list this matter again on 19/8/2025 for further hearing. Monday will not be possible. Wednesday, Pari? Oh, Wednesday. Any mention memos, give it to her. She will, if there is urgency for tomorrow, mention, otherwise give it to her. Whatever it is, you give it to her. She will give it as per the proper. Vacancies are there, she will accommodate.
I would like to mention item number 18, Your Lordship. Concern of the other side, Your Lordship.
Why?
Mr. Ganguly is not keeping well, Your Lordship.
We have fixed this matter today. A prayer is made on behalf of Mr. A. Ganguly, Lanark Council for the petitioner, that for an adjournment in the matter on the ground that he is indisposed. Prayer is not objected to by the Lanark Council for the respondents. Accordingly, registry to list this matter after 4 weeks on a date to be fixed by it.
Much obliged.
The matter, more to tied up. Is it parted with me?
No, Your Lordship.
No.
Some part was heard, Your Lordship, but that could be.
There is no parted.
No.
Yes.
He does done with senior counsel.
A prayer is made on behalf of 23 and 24. A prayer is made on behalf of Mr. D. Das, Learned Senior Counsel, for an adjournment in the matter on account of certain personal inconvenience. Also, prayer is not objected to by the Learned Counsel. You have informed the other side uh, by the Learned Counsel for the respondents. Full stop. Accordingly, registry to list this matter after 3 weeks on a date to. No date.
26, there is
No.
some urgency.
No date. Today,
Let a date after, there is some urgency, public money is involved.
you should have done it today. We had come, you should have given a circulator a memo. On 3/9/2025.
My pleasure, Lordship. I pray for listing a motion matter on tomorrow, Lordship.
What is the urgency?
Matter pertains to settlement of the market, Lordship.
Oh, market settlement can wait till Wednesday. Market already settled.
There is some urgency, Lordship.
Already settled.
Yes, Lordship.
Already
Now
settled.
the authority is going to run or operate the market through some private person, Lordship. Oblige, Lordship.
Lordship, I beg to make
Yes, why?
other side, they
This is connected to 37.
the matter are different, Lordship.
Okay.
Other side provide us the substitute. So we need some time.
37 and 38, you mean are not analogous matters. Be there. When the matter is called up, we will pass the orders.
That's on item number 19, my lord, joint pair lordship. In discussion of respondent Dima has filed an affidavit. Lordship. So two parties will have they have filed. Lordship.
Mr. P.K. Bora, Learned Counsel for the petitioner, submits that an affidavit on behalf of the Dima Hasso authorities have been filed on 30/7/2025, and he is required to bring a rejoinder thereto on behalf of the petitioner. Bring on record a rejoinder thereto on behalf of the petitioner. So, Mr. Bora prays that 3 weeks' time be granted to him in the matter. Also, prayer accepted. Registry to list this matter after 3 weeks on a date to be fixed by Ms. R.M. Deka, Learned Counsel for the Learned Standing Counsel, Dima Hasso is present.
Lordship.
My lord, may I
Please,
mention?
Lordship. Lordship, I beg to mention item number 15, Lordship. I'd like to pray for an adjournment.
Why?
Taken the consent from the other.
We thought we'll get a exposure to 143(1)(d) today. 1. You had filed a revision also there. The revision was not considered on merit, you withdrew it. I only wanted to ask whether this 143(1) is an assessment order. Normally, we also get notices that. So whether that is the end or it's the beginning, that was the query which I had for Mr. Saraf. Okay. Item number 15. On a prayer made on behalf of Mr. A. Saraf, Dr. A. Saraf, Learned Senior Counsel, for an adjournment on the ground of personal inconvenience, comma. A prayer is made on behalf of Liquid, yeah. Not objected to by the Learned Counsel for the respondents. Registry to list this matter again after 3 weeks on a date to be fixed by it. Interim order, if any, to continue till the next date of listing.
One more prayer with respect to a matter, Lordship, which is earlier Lordship had ordered us to
Give it to her.
highly applies.
That last matter which Mr. Saraf argued.
Yes, your Lordship. Highly applies.
My lord, may I mention a matter, my lord?
Yeah, Mr. Fukan.
My lord, there is a fresh matter which I am requesting if your lordship could post it on Monday, my lord. I would like
Monday
to.
would be difficult.
Lord, actually, I would be able to do it physically on Monday. That's the only
Monday
reason.
would be difficult because we don't know when we are coming back on Sunday. So you can have it on Tuesday or Wednesday, whenever it's
Tuesday, I would be deeply
Tuesday.
obliged if it can be
Tuesday.
given.
You can
Deep-
give the mention memo.
My lord, my colleague is there. He'll give it, my lord.
Okay, okay.
I'm
So,
deeply obliged, my lord.
Deeply obliged.
item number 1, we'll pass the order at 2 p.m. 2 p.m. You need not be here. I'll pass the order here only. Let somebody be here. Yes, Mr. Chaudhary, what is your instruction?
I have not received any.
Yes, where is the tender conditions?
Tender condition, my lord,
Where you require the
my lord, this judgment passed by some few days ago.
same issue.
Same, my lord, covered. Or, my lord, case analogous and past common judgment. Because, so far, my lord, clause number 7.1. There is a.
Why have you not brought the tender clauses before this court?
It was not my available on. when I
If
signed.
you're not available, you seem to be a very
But,
casual
my lord,
bidder.
I may read now this.
No, 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 no.
Petition, my lord. There is mandatory requirement site visit certificate that is to obtain by countersign from the executive engineer, my lord. That is the issue. Same issue, my lord. Condition is there. And my lord, direction will be given to the executive engineer to countersign, and I will submit the bid immediately, my lord, 1 or 2 days. Otherwise, I was prevented to submit my bid. Paragraph 8 and 12, my lord.
But there is a distinguishing factor here. In this judgment, the person had come in before the last date of submission of bids. You have
But-
come after
but
the last date.
I sought, my lord, because.
No, you went there, Mr. Bhuya, you went there on 24th, 23rd.
But this, I made representation on 28.
Why? Why
Prior
for
to-
4 days?
To expire.
No, no, no.
And
Why?
that
Why
was-
4 days?
That was received. on
You come to
29.
your photographs.
That
You come
receipt-
to your photographs at page 27. This was taken on 24/7/2025. Right? The second one is also 24/7. Third one is 23/7. What were you doing for 4 days?
But the petition was submitted on 28.
Why this delay in submission of the petition?
First expire date was 31st.
You can't wait till you could have Mr. Bhuya, you could have submitted that site visit required on 31st.
But prior to that,
Mr. Chaudhary, why have you not got any instructions here?
Lordship, I had communicated.
Why? We'll have it at 2 p.m. Get your details. At 2 p.m., Mr. Bhuya.
in the meantime, I will submit also this.
What that condition you just give it to me. Here the man was vigilant. He came within the time, so the court protected him. You are here after the last date.
Last date was 31st.
31st. You filed this
I have
writ petition.
Submitted on 28.
No. Be that as it may. But this writ petition was filed before this court on
Fourth.
4th. 4th. That is long after the
But
last date.
representation was submitted.
Okay, we will
But
consider.
on-
We'll
on-
consider, Mr. Yeah, we'll consider.
I love.
2 p.m. We have to issue a notice in this matter. Nothing heard Mr. H.R. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. A. Bhattchaji, Learned Counsel for the respondents. Learned Standing Counsel, Revenue and Disaster Management, appearing for the Respond number 1. No government advocate. Mr. Talda, learned government advocate appears for the also heard Mr. N. R. Talukdar, learned government advocate. Full stop. Issue notice returnable 4 weeks. Mr. Bhattchaji accepts notice on behalf of the respond number 1, while Mr. R. Talukdar, learned government advocate, accepts notice on behalf of the respond number 2, 3, 4, and 5. As all the respondents are represented, no formal notice is required to be issued. However, the Learned Counsel for the petitioner shall serve requisite extra copies to the Learned Counsel for appearing for the respondents. Also, raised to list this matter immediately after. Why 4 weeks? 3 weeks. 3 weeks. Issue notice 3 weeks. Full stop. On the next returnable date, the Learned Counsel for the respondents shall invariably file an affidavit bringing on record their stand in the matter with regard to the contentions raised in the petition by the petitioner. Also, in the event the affidavit is not so filed, the Learned Counsel for the respondents shall place before this court written instructions received with regard to the contentions raised by the petitioners in the petition. Full stop. Raised to list this matter after 3 weeks. Dubar nahi likhe na, ebare likhe. Before you start off, one query. The qualification mandated is 10 standard. 10 standard for that power operator or something, pump power operator. You have said that in your affidavit. What is that exactly?
Power pump operator. Power pump operator, metric standard.
Metric standard. What do you mean by metric standard? Metric standard, HSLC, same thing. What do you mean? Whether pass in class 10 or studying in class 10?
Pass lots.
And for pursuing an ITI course, what is the minimum qualification
What
required?
is the additional qualification?
No. What is the minimum qualification required for pursuing an ITI course?
To my instructions, class 8 mile.
Class 8 pass. Where do I get that? Because your case is you had never appeared, but you have a ITI certificate.
Fine.
ITI certificate normally is class 10, normally. But what it was in that position,
right.
we don't know. If it is found that it is matriculation, you're gone.
Fine.
You have committed a fraud here.
Fine.
So whatever steps they have taken, we will not.
Fine.
But if you can demonstrate that this is class 8 only, then we will have to give it a consideration on merits.
My instructions at that time, it was class 8. To my instructions.
Where there would be something, because you have not disclosed that. That was the main thing which would have been in your favor.
Fine.
Now, you have developed a story about you being transferred as a junior engineer, the persons therein, the head assistant not liking it, so may have done this. But that is a bit far-fetched. Now, Mr. Naik, in his records, service records, when did this matriculation certificate come up, dwell in for the first time?
First one recorded in the service book.
When? Where do I get that?
The service book, if you lordship, look at the service book, lordship.
Where?
Also it is there.
In the last round of litigation also, this issue was not raked up.
Yeah, I found lordship, although it has gone lordship. Lordship, his service was regularized on the post of electricity. He was yet to complete the required. That is why he was regularized as works as, but court.
That is a past
that is
thing
the
now.
loss has gone.
Now, The only issue is when did this recording was made with regard to matriculation qualification in his service book?
But my service book, I have extracted, my lord, from page 55, 54, my lord, is that right? copy?
54.
There, the date of birth is clear.
And date of birth, we are not worried now.
But the
But the
qualification is
qualification.
not mentioned.
Ah.
Qualification is not.
So
In fact, my lord,
when did this qualification come into your service book?
my lord, I did not bring it. And in fact, for the purpose of my promotion, I have filed an additional affidavit in reply. That's submitted. This HSLC certificate was never there. If my lord comes to page 146.
You have given a list of documents wherein the HSLC certificate is not there, whereas the other certificates are.
It is acknowledged, my lord. It's an acknowledgement. Page 146, my lord.
Okay. Now, if you come to page 57,
Pardon.
this was a communication issued to you by the executive engineer.
Yes,
What is your response to this? Where do I get your response to this?
my lord, I submitted a representation on at page 59.
59.
59, my lord.
This is in response to 58.
My lord, I was directed by page 57, which lordship had indicated, my lord. I was directed to produce the original certificate. I do not have the original. I told the engineer, the executive engineer, that I do not have the HSLC certificate and I cannot produce. Thereafter, my lord, 15.7 was issued at page 58. Here he mentions, my lord, in paragraph 2, that the undersigned is directed him to produce his original HSLC pass certificate by this office letter number so and so dated 11/7/22. Accordingly, he produced the original certificate bearing the same serial number and roll number, wherein his age is recorded as 16 years, 8 months, 0 days, as on 1st March 1979.
Where are you reading?
Page 58, my lord, paragraph 2 of the letter. The undersigned lordship finds, undersigned directed him to produce the original HSLC.
What is your response to that?
No, no, I verbally told him I do not have the original, sir. I do not have the HSLC qualification. And
Come to para 3.
my lord. In this regard, undersigned has communicated with the Board of Secondary Education. Oh, my lord, para 3 of my response, my lord.
Where is your regularization order?
Page 44, my lord. Pursuant to, my lord, the order passed by this honorable court, my
Can you get me that detail? What is this metric standard call for? And what was the qualification for this ITI thing?
My affidavit did
Metric standard.
Also say it's metric.
8th standard. When we say 8th standard, we mean studying in class 8. The metric standard would mean studying in class 10. That's the only opening Mr. Nair has.
It was in 1995, my lord. Sorry, well, 1990, my lord. The higher qualifications came later. No,
and is concerned. Is concerned, that situation also.
We will come to that.
Sure.
We will come to that. But here the projection made by you is where was that page 57? 58.
the letter to the chief engineer.
So he retired sometime in May 22,
July 20.
July 7/22. So, Mr. Naik, if your case is with regard to age only, we'll consider it.
Now it's
Now, if it is both,
really we were.
then the consequences on the petitioner would be very heavy. If it was the second one, we could have resolved it by way of Rafiq Mashik. One way of looking at it. Age. That rest part we could have said it would be re-employment. We could have given it a closure. Now here you have projected a case of fraud, basically.
And if the HSLC password itself is a fake one, Lord.
I got it.
Is recorded there cannot be.
No. I got it. I got it. But here his very promotion is also doubtful now. And if the ITI degree is also cannot be obtained without a matriculation,
That metric standard
is
not metric pass. Lord.
no, if it is
That
metric pass,
situation, so far as the first appointment is concerned,
it's also gone. Will also come under cloud.
directed by your lordship, I have some.
Judgments will come, but let us first resolve the facts. So, Mr. Nayak, can you get that?
I'll try, my lord, because my instructions, it was class 8 at that point of time in 1978.
But I'll have to have something
I
concrete.
will try to obtain my.
I'll have to have something very concrete here.
For ITI lordship, it may. But for the post lordship,
My lord, sorry. My
No,
lord, in the
no.
metric standard came in
standard plus
in
ITI,
1990.
Mr. Nayak, if it is metric standard,
plus ITI.
ITI, and if the qualification for ITI is only metric, if it is, you know, only class 8 pass, and the person has studied in class 10, he does not pass. The certificate also does not say he is passed. He has studied till class 10, that would be met. That is the issue now. That is the issue. Because he disputes that.
Pump operator qualification metric standard plus. ITI
That
pass.
was I'm saying. If it is metric standard,
Or
if it is metric standard, and we hold that metric standard to mean metric pass,
when if it is found for admission to ITI, it is class.
then he has a case, Mr. Nayak. Why I'm telling you? Metric standard and metric pass, you will have to show is the same thing.
One lord.
One, if it is metric standard and the interpretation is that it is reading in class 10, then admission to ITI, if it is class 8, then his story fits in. Then I can say that you have not taken any step against him during his service period. After retirement, the only thing you can do is to withhold his pension, and that too for a thing which had arisen 4 years prior to that. If it is within your competence to do that, you can proceed and do that. But for that, I'll have to understand whether one, for ITI, whether metric pass is required. If not, fine, class 8, he has ITI. And your disqualification metric standard would mean metric pass or metric study. That's much only, get me?
The other aspect, my lord, is at the time when I was engaged. because the
That you
rules-
bring it,
No,
you
because-
bring it. You have
no,
not even averred.
My lord, one of the rules which they are relying on is the 1990 rules. These were not there when I entered service.
Your regularization was of 97.
Fine.
So the 90 rules will hold the field.
But that was subsequent to, my lord, pursuant to the High Court's.
You get me these things.
The ITI, I'll.
Man is not even given a provisional pension.
No, my lord.
Why?
Because in 2020.
Have you passed any order dismissing him, rejecting him? Have you passed
In
any?
2024 lot.
Fine, you initiate if it is within 4 years, but he is entitled under 21 to get a provisional pension. Give him that. No, that is only till you, because here you have not come to a conclusion. It's still in the contemplation stage only, right?
That is my stand in the affidavit.
That what?
Only protection I am,
What?
Your Lordship, it is found.
We are not bound, we are not binding you down. But what I'm saying is that
In
there
that
be-
situation, it will be open for us to recover.
fine, you do
Recover
it.
Pensionary amount.
You do it. You do whatever you want. But today you will have to give him subsistence, provisional pension.
That liberty only, Lordship.
Okay,
One observation, Lord.
okay. Heard Mr. P.D. Nayak, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned standing counsel, Public Works Department, appearing for the respondents. Irrigation, standing counsel, irrigation, appearing for the respondents. Full stop. Mr. Nayak has submitted that the petitioner had retired from his services on reaching the age of superannuation with effect from. No. We will see, we'll see. On 31/7/2022. However, he has not been authorized a provisional pension. Full stop. Mr. Nayak further submits that no proceeding were initiated, no proceeding either departmental and or criminal were initiated against the petitioner during his service tenure, and no such proceeding is pending as on date. However, the respondents have raised apprehension of the petitioner's matriculation certificate, which purportedly was furnished by the petitioner to be a fake one. Mr. Nair has submitted that the said matriculation certificate, which is relied upon by the respondents, was not so furnished by the petitioner, and he had not passed, then the petitioner had not passed the HSLC examination, HSLC / matriculation examination, and had only studied till class 10 before joining his service, before persecuting his ITI course. Also, per contra, Mr. Nayak submits that the petitioner had submitted contradictory past certificates pertaining to his HSLC qualification in the record, and therein the age of the petitioners were also different. Also, a doubt having arisen with regard to the certificate produced by the petitioner on being so required by the respondent authorities, the said certificate was forwarded to the authorities of the Board of Secondary Education, Assam, for verification. And on such verification, it was found that there was no candidate appearing in the year 1979 with the name for the HSLC examination with the name Indrajit Sen. Further, the roll number and the roll number of the petitioner was also held to be not belonging to him. So, under these circumstances, the respondents concluded that the petitioner's initial entry into service was by way of a misrepresentation, and accordingly he would not be entitled to any benefit with regard to the continued service rendered by him, and accordingly his pension and pensionary matter was not processed. So, Mr. Nayak further submits that the respondents are contemplating to institute departmental proceedings against the petitioner, and accordingly submits that this court would refrain from passing any directions for releasing to the petitioner his provisional pension. Full stop. Having noticed the submission of the learned counsel for the parties, what emerges therefrom is that the petitioner had admittedly retired from his service on reaching this age of superannuation with effect from 31/7/2025, and during the period he was in his service, no proceeding was instituted against him in the matter. Also, under such circumstances, the petitioner, further, till date, it has not been brought on record that the petitioner has been brought on record that any departmental proceeding has been instituted against the petitioner. Also, in the above view of the matter, this court is of the considered view that the petitioner was entitled to be to receive his pension and pensionary benefits. However, considering the submissions made by Mr. P. Nayak that there is a doubt with regard to the matriculation certificate produced by the petitioner, where there is a doubt with regard to the qualification procedure. However, considering the submission of Mr. Nayak that the matriculation certificate produced by the petitioner having been found to be a forged one, his very entry into the service is questionable, and accordingly the respondents are within their rights to institute appropriate proceedings, if so permissible under law. So, the said aspect of the matter would be considered on the next date of listing upon the learned counsel for the parties bringing on record materials to demonstrate the qualification required to be possessed by a person to hold the post of power pump operator as of
1982.
1982,
86.
86, and also the qualification required for pursuing a course, pursuing an IIT course, ITI course. Also, however, noticing that the petitioner has not been subjected to any proceeding till date, this court directs the respondents to release to the petitioner his provisional pension with effect from the date subsequent to the date from when he had proceeded on superannuation, that is, with effect from 1/8/2022. Also, the petitioner would also be entitled to be released his provisional DCRG inasmuch as no proceeding is pending against the petitioner as on the date he had superannuated from his services. Also, the respondent authorities shall also release to the petitioners his leave encashment and other pensionary benefits. Full stop. The processing of the matter for releasing to the petitioner his provisional pension, pensionary benefits, leave encashment and other pensionary benefits would be so made and concluded within a period of 1 month from today. The arrears be released to the petitioner thereafter within a period of 1 week. Also, it is provided that the direction passed herein above for release to the petitioner his provisional pension and other pensionary benefits would be subject to further orders that would be passed in the present matter. Full stop. With the above observations, full stop. Raised to list this matter again after 6 weeks on a date to be fixed by. Full stop. Today is 5th. 5th is on 15/9/2025. So this matter would not be treated as a parted and or tied up matter with this court any further. You give him, I'll give him 15 days then. 15 days, you release this amount, come back thereafter. We want to have that petitioner something to, no, we want 1 month to release the benefit. 1 week.
Paying for listing this matter on 3rd.
It will not be, it will be 1 month would be 5th September.
Today is 6th.
6th. So it will be 5th September. 1 week would be, I'm giving you a date before that, 15th. Hold. Okay. You do some proceeding, then only we can, you close our hands. Without that, we can't. Last time I forgot this aspect. I had thought about it, but in the mel of the matter arguments, it left out. So I put it today.
Add on 31/7/24.
22 day, 22. I'll go through it.
Fine,
So-
fine.
Yes, next.
Deeply.
Madam on naam to le lo. Appears for respond number 9 likhi lo banamko. Didi bar hai. Had likhi jana upor tale likhi dibo. No adjournment. Adjournment prayer rejected. Yes, make your submissions.
Please, Your Lordship. My lord, I'll just confine my,
RCT Act to devotion. RCT Act.
but I'll just confine my submission. For claim of the.
I am not barring you. You can always approach this court by way of appeal, MFA,
23, my lord. Under 23, I can approach.
subject to the provision of limitation.
My lord, the purpose of filing a writ petition of 23 was to obtain a direction towards the Railway Claims Tribunal, because, my lord, the petitioner.
And how can you file this case under 226? We are having superintendent's power under 227. I would have understood a petition under 227. But this is a petition under 226. How can I issue a certiorari to a quasi-judicial body, basically? We have a power of superintendence. If you look into the Guwahati High Court rules, Act and rules, we have a power of superintendence, page 361. এইখন নাই, নতুনখন নাই নেকি? এই মোটা এটা আছে। এইটো। একে নেকি? এইটো details.
That a direction, since the tribunal is not complying with the law laid down by the High Court.
I'm sorry, that is a issue which you can always raise in an appeal. Could have raised in an appeal. There was no requirement of filing a writ petition here.
Your Lordship may just consider one judgment, my lord. I'll be
Yes.
done with my submission.
Mm.
My Godrej Sara Steel, Honorable Supreme Court in para 4, if your lordship may highlighted the relevant portion. My lord, if I may read.
Yes.
Before answering the questions, we feel the urge to say a few words on the exercise of the writ powers conferred by the Article 226 of the Constitution. Having come across certain orders passed by the High Court holding a writ petition as not maintainable mainly because an alternative remedy provided by the relevant statute has not been pursued by the parties desirous of invocation of the writ jurisdiction. The power to issue prerogative writs under Article 226 is plenary in nature. Any limitation on the exercise of such power must be traceable in the Constitution itself. Profitable reference in this regard may be made to Article 329 and ornaments of other similar worded articles in the Constitution. Article 226 does not in terms impose any limitation or restraint on the exercise of the power to issue writs. While it is true that the exercise of the writ powers, despite availability of remedy under the very statute which has been invoked and has given rise to it, rise to the action impugned in the writ petition, ought not be made in a routine manner. Yet, emphasis applied, my lord, the mere fact that the petitioner before the High Court in a given case has not pursued the alternative remedy available to him, it cannot mechanically be constituted as a ground for its dismissal. It is axiomatic that the high courts, bearing in the minds of the facts of each particular case, have a discretion whether to entertain the writ petition or not. One of the self-imposed restriction on exercise of the power under 226 that has evolved through judicial precedent is that the High Court should normally not entertain a writ petition where an effective, efficacious alternative remedy is available. At the same time, it must be remembered that mere availability of an alternative remedy of appeal or revision which the party invoking the jurisdiction of the High Court under 226 has not pursued would not oust the jurisdiction of the High Court and render a writ petition not maintainable. In a long line of decisions, this court has made it clear that availability of alternative remedy does not operate as an absolute bar for maintainability of the writ petition, and that the rule which requires a party to pursue the alternative remedy provided by a statute, my lord, is a rule of policy convenience and a discretion than a rule of law, my lord.
There is no quarrel with this proposition. This is a revisional power exercised by the tax authorities. Why this? There are umpteen number of decisions that this court, even there is an appellate provision provided there, if it is demonstrated before this court that the notices were not issued, there was a violation of the principles of natural justice or a challenge to that very provision of law is made, a writ would be maintainable. Otherwise, it's whirlpool. The exceptions of whirlpool. Here, the grounds that you have taken for assailing the order of the learned tribunal are grounds which can very well be taken in an appeal. It's not that the member's jurisdiction, if you have taken a question that the member's jurisdiction to pass such orders, violation of orders passed by this court, these are grounds of appeal. So, in that circumstance, why should we entertain this writ petition?
Lordship, in that case, my lord, I pray that Lordship may grant me of this writ petition. I'll file a fresh miscellaneous first appeal for the claim, my lord.
That is as per law. Mr.
D. Rathi.
Mr. D. Rathi, Learned Counsel for the petition, after attempting to argue the matter at some length, has submitted that he be permitted to withdraw the present writ petition with liberty to invoke the provisions provided under the Railway Claims Tribunal Act 1987 to assail an order passed by the tribunal in an original in an original application filed before it. First up, prayer is not objected to by the Learned Counsel for the respondents. First up, in view of the prayer made by Mr. Rathi, Learned Counsel for the petitioner. This court proceeds to dismiss the present writ petition on withdrawal. Full stop. Liberty is granted to the petitioner to file appropriate proceedings as mandated under the provisions of the Railway Claims Tribunal Act 1987, subject to the same being maintainable under the provisions of Section 23 of the said Act of 1987. Ubo?
Much obliged.
On the 14th of July. I would like to pray.
Just tell me, his only case is that on the date when the results were declared, which again is sometime in 13/3/24, and that communication has come on 13/10/24. So you had around 7 months in between. You were inactive, and finally you come up and say that this is gone. So we wanted to know, when did you take that decision? Because the copy here is the communication of a decision. When was that decision taken? I think that was the query. Yes, page 67, this decision of 13/10/24 naturally was not taken on 13/10/24. It was taken prior to that. When? And what is the form of that decision?
The same date, 13/3/2024, another select list was published in respect of media expert. They
That was appointed.
appointed.
That's why I'm waiting for some time. Lordship. He might have the proper instruction.
Where is he? After that, he can come down.
Yes, sir.
We are keeping it for time being. Yes, Mr. Gugui. Forget it. All these cases, it's a DG set basically. Now let us take up the first matter. 6731/2024.
6731.
Okay. When was the tender made for this?
Lordship will find a page.
Give me the dates.
It is 31 executive engineer. This is my lord. 31/3/23.
31/3.
Well,
20.
administrative approval. This is the approval.
This is where is the tender?
My lord. Then this is my lord, at page 17. This is the revised estimate for technical sanction.
Mr. These are where was it put to tender? Where is that tender? I want that tender. Huh?
Page 40, the annex the work order only, Lordship.
The work order is there, I know. But where is the tender? Where is the tender, Mr.?
The papers I have.
So that is what we'll have to look into, first and foremost. And the stand of the respondents in the affidavit is
That it was, they have never denied that I have not estimated or.
no, your estimation is not of any consequence. The estimation is whether the work that was given to you
Yes.
also included a DG set.
Yes, that's what I want to place it before Lordship.
Show it.
Your Lordship may look into the sanction. It is true there, the sanction and the tender documents are related components. Sanction, Your Lordship will tender.
We'll have to presume that.
My lord, at
We'll have to
ten-
presume that.
sanction, Your Lordship will find
Hmm.
at page 18, serial number 8.
That is a DG set is there.
Approval in my additional affidavit, page 77. Page 77, this is, my lord, what I place it, this is minutes of the third sitting of the state level scheme sanctioning committee on 4th November, and that was DG set was approved. Last paragraph.
This is dated.
This is dated, my lord, 4th November 2022. And they have stated. or they
Now,
have-
when was the work order issued to you?
Work order is page 40. Page 40, na?
No.
Where is that?
45.
45. It is 18/5/2023. Paragraph 4 of their affidavit says that by later dated 1/7/23, they excluded the DG set. Paragraph 4 in their affidavit, page 131.
Page 45 with 48 would go to show that a DG set is required.
Correct.
Huh? So when did you submit your first bill?
I submitted the bill which, in my affidavit, my lord, you also will find at page 118, tender for works, then thereafter, my lord, the bills were submitted. Running bill, page 124, 18/5/23. Work order 18/5/23.
That is work order. Where is
Work
that? When did
The
you
bill
submit this
was
bill?
approved.
1/2/24.
2/24.
And when was this? There is a report somewhere of verification that this DG set was already installed. There I found somewhere. Where do I find that? That a report from some officer in the field level that this DG set was already.
At page 55, Your Lordship.
55. Mr. Chaudhary, is the correct?
DG set of 150 found installed in commission site. Page 55.
What is the date of this?
Yes.
2/2/24.
Date of inspection is
6/2/49.
49.
So now show me the document by which after you had issued a communication, right? That DG set should be excluded.
Page,
When was it communicated to him?
page
Because-
58, rejection order, page 58.
Page
Rejection order.
58.
That I have got it through the. So date was given wrongly. Page 59 is that, my lord, a copy I got it from there. DG set placed contrary to the office order dated such and such, it is written as 1/7/27, it cannot be 1/7/27. Original such and such, page 59. Page 58.
So you took a decision. You gave him a work order prior to that decision, 31/3/23. He installed the DG set, maybe immediately thereafter. You approved it on a site basis, so the DG set is there. Now you take a decision on 22/7. That
1/7.
7/23.
1/7/23, you take a decision to exclude DG set. But in the meantime, if in accordance with the work order, he has already given it to you, then how can you deny that to him? Or show me that immediately after 31/3/23, before he had placed the orders and brought the DG set, you had communicated to him, we don't want this component. He would not have bought it. Now he having bought it, you cannot saddle him with that.
I will take some documents this morning. If I may, Your Lord.
When did you buy this DG set, Mr.?
The date is not known.
But there would be a date of installation by you. Can you get me that date when he actually installed that?
But just if your lordship permits me, in their affidavit, the last line they say, further the scheme approved on such and such, DG sets were excluded. But this is the first, second, third, fourth SSLC state level, but we have annexed the affidavit
It is not there.
and that they have approved there.
In the first meeting, they had approved this.
Now, arises once all of the GG said, they have to take a decision to
But you
no
cannot.
communication was made to him. That
No
was
communication made to him. If he had not brought it, it would have been a lapse on his part. You would have proceeded against him.
exactly.
Now the reverse thing, you cannot do that. He
Subject
is
to
entitled.
correction, my lord, I am entitled to quantum merit.
We need not go that far.
Well,
Section 70, Contract Act. Work not done gratuitously. And in none of these SSA meetings can you show that prior to 1723 in the SSLC, SLSC meeting, SLSS meeting,
SLSS.
this decision that don't buy the, what do you call that?
Agents are bad, agents
Where do,
upon the submit.
1423.
There's an excluded.
These will be prospective in nature. All this would be prospective, cannot be made retrospective. So how can you be denied to him? We cannot deny it to him.
They have shown.
Huh.
It says that
59.
date
DG set place contradictory to this order 17.
Yes, sir.
23 it should be.
23.
23, okay. But that decision prior to that was never communicated. So you also admit that it was never communicated.
So my instructions are never coming.
Anything more?
Instruction on all these parts, whether because in my verbal instruction, one communication was made.
But I'll also then require on the dates on which he had installed those.
I will get that. Lord.
Mr. P.K. Roy Chaudhary, Learned Counsel for the petitioner, and Mr. R.R. Gogoi, Learned Standing Counsel, PHE. PHE. Mr. The materials brought on record goes to indicate that in the work order issued to the petitioner on 31/3/2020, in all they say it's 31/3 only.
I am appealing for 6. No. All.
All 31/3. All work order is 31/3, right? Item number yet 6731, 2024. Also, the work order issued on 31/3/2023 also included a provision for supplying and installation, testing and commissioning of air/water cooled diesel generator. Also, the petitioner contends that he had, in terms of the work order given to him, procured and installed a DG set, diesel generator set. Bracketed DG set diesel generator set. Also, thereafter, the set generator was also commissioned. Also, the petitioner thereafter raised his first running bill. Also, for the purpose of preparation of the said running bill, the departmental authorities had carried out a inspection of the works done by the petitioner till the said date. Also, the inspection so carried out, having also brought to the forefront the commissioning of a DG set by the petitioner, the first running bill so prepared also included the amount receivable by the petitioner for the purpose of installation and commissioning of the said DG set. Full stop. However, the respondents, on processing the matter, proceeded to reject the claim made by the petitioner for being reimbursed for installation and commissioning of the DG set by contending that the departmental the chief engineer, bracketed water, PHC, via a communication dated 1/7/2023 had required exclusion of the DG set from the schemes which were approved prior to 2022-23 for and wherein preliminary work orders were issued after 1/4/2023. Also, in the case on hand, admittedly, the work order was issued on 31/3/2023. A bare perusal of the communication dated 1/7/2023 would go to reveal that the same cannot be made applicable in respect of the petitioner herein, who was issued with the work order on 31/3/2023. Also, further, the materials brought on record does not reveal that after the work order was so issued and within the scope of the work allotted to the petitioner, also the procurement of a DG set and commissioning of the same was included, Can I aramba koriছিলো? Aramba কেনে করিছিল? So and so. However, it is not demonstrated that before commissioning of the said DG set by the petitioner in terms of the scope of work allotted to him, he was issued with any communication requiring him not to procure and install the said DG set. Also, Mr. R.R. Gogoi, learned counsel for the petitioner, submits that he be granted a week's time to complete his instructions in the matter and apprise this court as to whether the decision contained in the communication dated 1/7/2023 was at any point of time prior thereto communicated to the petitioner. Also, the learned standing counsel, PHC, shall also place before this court on the next date of listing the date when the petitioner had installed the DG set after being issued the work order on 31/3/2023 and whether prior to such installation he was required by the departmental authorities by way of a written communication to exclude procurement of the DG set from the scope of work allotted to him. The said instructions be placed before this court on Mr. Chaudhary when? He did. Onnina Pari, Papuri. Bodiri Pahurijum. Full, no? 19.
One thing, I just went through the work order, the work include your lordship.
No. No.
If I your lordship, work.
No. It is there. you come to page 45, down below, middle, details of the scheme with estimate cost as per Annexure A. Now, where is this Annexure A? Because this Annexure A was there, that is why item number 4 DG set was there in the first running bill. Otherwise, it would not have been there. Where is this Annexure A?
It's not annexure, this is the.
Where is this Annexure A?
What I find from the documents is not there.
So, Mr. The Learned Standing Council, Irrigation, PHC department shall also apprise this court as to, shall also furnish before this court a copy of the Annexure A enclosed to the work order, formal work order issued to the petitioner on 18/5/2023. Right? If it is not there, he is gone. Very easy for us.
What I find that Annexure A is that revised, my lord, affidavit we have given, that one, your lordship will find there. Page 45, your lordship will find. Annexure A, page 45.
Where is Annexure A?
Your lordship, in 45, that is approximate value of offered value such as per Annexure A. This is the particular sanction. Continue to be. Sanction চেষ্টা করতে হবে। কিছু দেখোস না। এটা কোথায়?
No, if there is an Annexure A and it is there, that is there,
Contains that.
then it's finished.
At page
124. This is the work order. This is the bill. Okay, I have only recorded it as a submission. You counter it on 19 as for further hearing ko area. Baki kita, item number 9, 10, 11 and 12.
work orders will be different. Work order.
No, 11 and 12, eta order mariba, list it along with WPC 6734 on 19, 8, 2024 for 25 for further hearing. Mr. Aman, make a chart, work order, the work order number, first running bill, and the date of installation of DG set in each of that. When was it procured? With documents. When was it procured and when was it commissioned? Commissioning would require somebody from the department also. Just indicate that also.
All right.
Mr. R. Borpujari, main man, Learned Standing Council Finance is present and watching the proceedings. Okay. Yes, Mr. Chalia, what has happened?
We have returned both the PPOs to the accountant general.
Get hold of Mr. D. Bachaji and bring him. Mr. Chaudhary, where has it reached?
On the last occasion, time was taken for filing an affidavit that has not.
That is not been filed.
But this order, my lord, the minutes of the meeting.
I don't understand, Mr. Chaudhary, one factor here. If you can come to the affidavit filed by on 39/24 by the liquidator affidavit. At para 6, he is replying to your para 10 in your reply, that these are the numbers. He has not disputed that, right? He has rather placed an alternative proposal before you. If you can come to page, internal page 56 or running page 103. What is the total cost of these materials, Mr.?
That has been calculated. In fact, my lord, there is a meeting held on 5th of March 2025. My lord, a copy was produced before your lordship on the previous date. My lord, your lordship may kindly peruse. There is no dispute. Only thing he says that the government has to make the money available.
No, he has also made a alternative submission here in page 103. Now this Indian agencies which were given to various state fed
State fed agencies.
agencies, are they still continuing?
No, my lord.
They are gone.
Have been, my lord, terminated.
And have you paid the money you collected from them?
Lord, those are our, my lord, equipment, the gas
No,
cylinders.
no, they had, if you can come here at page 56 of that affidavit, internal page, or 103, whatever it is. Just below that. Second paragraph, it is stated that
something
four
different.
numbers of,
The state fed Indian agencies deposited money in IOCL against supply of fuel cylinders. But they were not supplied the fuel cylinders. The names of the agencies and the amount of money deposited were informed to the IOCL authority by the letter number so and so dated 20th of February 2015.
so this much amount they say is with you. It's very paltry, but some amount is with you. Now you come down below, next page, as the IOCL had not refunded so and so, may be adjusted against the pending. So and so, moreover, at the time of providing LPG's Indian agency to so and so, 5,000, the license fee deposited may be adjusted against the penal money. So this adjustment you can make immediately because they have undertaken to that. Now, so Mr. Talukdar, once you have admitted to that claim, release that money. You are already pursuing the matter with the agencies before the trial court. The other proceedings have come to an end. Only the trial, some civil proceedings that you have initiated, that is going on. You make your recoveries from there. But why should the IOCL authorities? Because this equipment is to be used for the public only.
It is represented by advocate.
Who is he? You are for? Okay. You are? You have to make the money. You have to clear the money. You have to clear. What happened to these establishments, State Fed Haflong Indian Agency, State Fed Tamulpur Indian Agency? These were all on your land. Right, Mr. Talukdar? These were all situated in State Fed land.
Yes, ma'am.
Have you sold those land? You have a huge asset. If it is liquidation, either the government takes over that land or you sell it in the open market, get the money, clear the dues. Because these cylinders have to, there is a shortfall now of this much number of cylinders in circulation. So this much number of people are suffering. They may have made alternative arrangement, that's a different thing altogether. But this much is missing and these are their property. What do you propose, Mr. Chaudhary?
It appears that they might have sold cylinder.
They cannot return now. The money should be given. With interest. Oh, it's a government agency, no interest.
Yes, we are not claiming.
Claiming only that 62 lakhs 81,500. So, why are you not making use of your assets to clear the dues? You are just sitting over the matter. You have your assets here. Have the assets been taken over by the government?
Monday will.
Have you, whoever is appearing, you are there now before me. The assets, what is liquidation? You have an asset. Who is holding those assets now? State Fed assets, properties, buildings. At least I can identify here 4. That is, 1 is enough to clear the dues. Why?
Even 1 is not required.
1 is also not required. Prominent places. Haflong we leave it, Tamulpur we leave it. Not Lakhimpur and Jagra. More than enough. Jagra is enough. Nalbari. More than enough. So, what are you doing as a liquidator? Asking government money? You are the liquidator. Is the liquidator not empowered to?
That is why, my lord, paragraph 3 of the minutes, my lord, I was wondering, my lord, how can the government come into the picture? Because from the assets itself, my lord.
No, who is holding the assets now?
Liquidator,
It's under the liquidator still.
let the matter be taken up. The best person, my lord, to apprise your lordships regarding.
Lekha. Heard Mr. Heard Mr. M.K. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. S.K. Talukdar, Learned Counsel, Standing Counsel, Corporation Department. Also heard Mr. S.S. Bora, Learned Counsel, appearing for the liquidator, respondent number 1. Also, Mr. Chaudhary has placed on record a minute of a meeting held between the liquidator State Fed and the representatives of the Indian Oil Corporation on 6/3/2025. A perusal of the said minutes would go to reveal that the cylinders and pressure regulators claimed by the petitioners, by the IOCL authorities, cannot be returned by the liquidator in as much as the same are not traceable as on date. Full stop. In view of the set position in the set meeting, the parties had agreed that the IOCL authorities would be required to be paid an amount of rupees 62,81,500 bracket rupees 62,81,500 only for the as compensation for 3079 numbers of cylinders and 235 numbers of pressure regulators. Mr. Chaudhary has submitted that the IOCL authorities are claiming only the said amount and would not be claiming an interest thereon. Also, a perusal of the said minutes dated 6/3/20 further brings to the forefront that the liquidator had liquidator while acknowledging the claim of the petitioner, IOCL, had undertaken to make the payment of the said amount provided the government of Assam allocates sufficient fund for the same. Fusa. The liquidator is in possession of the assets of the erstwhile State Fed. It has not been brought on record as to what has been done with the said assets and or if the said assets have already been taken over by the government. The liquidator on the next date of listing shall apprise this court as to what he proposes to do with the assets brought under him of the erstwhile State Fed and or whether the said assets have already been taken over by the government. Basing on the clarification submitted in the matter by the liquidator on the next date of listing, this court would pass for appropriate orders as would be called for in the matter. If the government had taken over, the government will pay. If not, he will have to do something.
Proceeding is going on from 2010.
10 employees were paid. That, okay, government. Now, how you have it with you? Either you give it to the government, take the money, pay, or advertise through the process required. You cannot sit over the matter for last 15 years. I know what liquidation is going on. I was also a part of the employees. Mr. Chaudhary was preceding me in the matter. So we know how the things work out. But this is not done. No, we don't want it. Next day, you give me a copy.
My lord, one copy I had.
It's on record. Just a minute, if it is on record. Oh, it's on record, it's on record. It's on record. Oh, list this matter again on Undina Pari. Uthoro. No, Jodi Digdari ase kwa. 20. On 20. There's too many matters. So we'll have to distribute. 28.
After long, but
I was thinking Mr. Vishwas has
now,
abandoned this court.
yes, now the vigilance has gone after long gap.
It's
While
gone.
High Court has directed, what is the status? They have gone.
We'll give them some time. We'll monitor.
Yeah.
Heard Mr. S.C. Vishwas Learned Counsel appearing for the petitioner, and also Mr. N. Goswami, Learned Government Advocate. Also, Mr. Goswami has placed before this court an instruction received by him from the Senior Superintendent of Police, Directorate of Vigilance and Anti-Corruption, and to Roman Hobode, Assam. A perusal of the said instructions would reveals a perusal of the said instructions reveals that the investigating agency has started the investigation in the matter and have brought around 12 officers within the ambit of the investigation. It is submitted that substantial progress has been made in the investigation. However, issue arising therein pertaining to the disproportionate asset processed by the 12 officers brought within the purview of the investigation, some time would be required to take the matter forward. Also, some time would be required to bring the inquiry to its logical conclusion. Also, appreciating the efforts taken by the investigating agency in the matter, this court allows further 4 weeks time to the investigating officer for investigating officer, for further investigation in the matter. So, on the next date of listing, the investigating officer shall place before this court a detailed status report and highlight therein the steps taken by him for the investigation of the matter involved. Also, the investigating officer shall also, on the next date of listing, in the status report, indicate the time frame by which the process of investigation can be brought to its logical conclusion. So, registry to list this matter again on 8/9/2025. A copy of the instruction furnished by a copy of the instructions dated 6/8/2025 furnished by Mr. N. Goswami is kept on record and marked as X. We'll see, Mr. We'll monitor now. Yes, Madam Chakravarti.
Unusual.
No, your coming here is unusual. The case is more unusual. Yes. You're ready? Okay.
But the contractor, he throughout his lifetime, he saved money for these days that when he is working, he may get pension out of it. So that was the policy he took. And as per under policy, it was to be made. There, he was supposed to get some pension of per month.
Per month.
After his lifetime, maybe his
Lakhs for his the hairs.
Yes. He retired from his.
Well, let us go step by step. The policy is called Jivan Taran. And the premium payment period was from?
It was 2016 onwards,
or 2011 to 2016?
from 2011 to 2016.
So total premium paid was 7,83,500, right? No. Total of 47 lakhs. This is per annum. 7 lakhs is per annum. Then bonus was 66,000. Maturity
Till 2022.
Yes, what happened thereafter?
But he retired from his job and then he went to, he was staying in Bangalore. Because of his health issues, he had to stay there. His and wife's health issues. Now there he gets a phone call from Canara Bank that there is some.
What was it? Which bank, from which bank he was making this payments? His banker was Canara Bank only?
No,
Never. No, then?
this is Canara Bank. He gets a call from Canara Bank Joy, that is in Jantia Hills. So he never visited that place. He stays in Cedar only. He has no connection with this bank, neither with this Canara Bank nor Central Bank. Both these banks are involved in this.
So, first is Canara Bank. There the loan amount is 4,50,000. Less than that, maybe with the interest, it is 4,50,000. And Central Bank is 13 lakhs.
Central LIC
Huh?
was regulated through the Central Bank.
Okay. Loan from LIC through, why this has to be through Central Bank?
Okay.
It was paid to his account.
Oh, his
He
account.
paid it to his account.
Okay. You deny that you have taken these two loans.
Saying that this LIC policy, against this LIC policy, was created. Therefore, I get a call from, thereafter I come back to Silchar and inquire into the, I go to the LIC office. They shows me that all these documents, my lord lordship finds.
The originals were mortgaged.
Oh, they are saying they have the original. I have the original with me, my lord. I'll produce it before your lordship. Now, all through the stand of the LIC also in this case is that I did not produce the original copy before. All through when I had taken up this matter with LIC, I had produced the original copy with it. They had perused it. Even a police case was filed. Police was also, my lord,
What happened to that police case?
is, my lord, during the course of this proceeding, now I get to know they have closed that proceeding. I have filed a Naraji petition there. LIC had also filed a police case that is still pending.
So final report submitted.
Madam Chakraborty, policy is one. Two loans. One with LIC, one with Canara Bank. In both these loans, how come the original documents were given?
That's my question. So apparently it's a fraudulent act.
We have the Canara Bank here.
Yes, they are impleted.
Mr. Sharma, for another court lordship, may I kindly fix it, lordship?
We have started off, you would have told me earlier.
Let us continue. In the meantime, whatever he has to say, he may say. I want to catch hold of him actually.
Yes, Mr. Kundu, what is your case?
Representing LIC lordship.
Now, LIC, general perception. We don't know whether if you have any special conditions. If any loan is required against a policy,
Assignment of the policy.
I will have to sign on that policy, assign the policy, and the policy will be given to you. A photocopy will be given back to me. Where is that original copy of the?
10 lakhs rupees is his account. And that aspect has not been denied by the.
You forget that. First, tell me, how could you sanction a loan without the original? Only by the agent saying that he has seen the.
Have taken the original and we have sanctioned the 13 lakhs loan and we had credited the account.
Where is that original?
Original, Lordships, original not with me at.
No. Where have you stated in your affidavit to that effect that the originals are retained by you?
Otherwise, their affidavit.
Lordships,
Because she has very categorically in one of her paragraphs stated that the originals are with her.
In their affidavit, page 6, they themselves are saying that on inquiry, they found that this
Come
amount.
to para 5, page 8. In response to the said letter dated so-and-so, I was asked to visit with the original documents which he did, the nature of fault, so-and-so, 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 again with the original policy. Did visit but refused to hand over the same, having lost faith on them, and since they are constantly pressuring for conducting, to hand over the original policy to them. Without the original, what is your stand in the affidavit?
Lordship, page 8, para 8, Lordship, page 6.
Affidavit, any legal cell filed by one Rumi Burwa. Paragraph?
Lordship, page 6.
Before that, if Lordship starts from page 5, last 3 lines bottom. Later, after further inquiry with the Central Bank of India, Silchar, it was informed that an amount of rupees 4,80,000 was debited on 21/12/2017 from the above bank. Amount was credited to the bank account of one Tushar Kanti Das. They themselves are saying that the amount is credited. It is their statement, their affidavit.
Our statement, what is later after inquiry with the Central Bank of India, Silchar.
Okay, fine. It's a fact. Fact. Okay. Now, where is that thing? How could you, your officer, what steps have you taken against this officer of yours? That he sanctions a loan without the assignment of the policy.
And he has not assigned any policy. Our case is not. That. Simple case is that.
Mr. Counsel, the loans these days are not by way of a check. It is always you sanction the loan earlier, the earlier period, it was you give him a check or a banker's draft or whatever it is. Today, that is replaced by transfer to an account. That is only the mode of release of the loan. How did you sanction the loan without a assignment of the policy to you? No. You have filed an affidavit. Why should we give you time? This matter is pending from 2019. That fraud happened there. Was your signatures taken for FSL?
Nothing. Vigilance, I have given a vigilance complaint also, Annexure 11, my lord. Since 2011, they have done nothing, my lord.
We have not done any Lordship. We have go to the visit we called him with the
Mr.
original.
Kundu, your plea that the money was credited to her account is not enough. That is not enough.
That was confirmed by the.
Fine, confirmed by the petitioner.
By the account bank. Lordship. That
Okay,
was
fine,
confirmed with
let the bank.
It is
How did you sanction that amount? How did you sanction that amount? Have you made an inquiry? How this amount could be sanctioned?
Worships, we have to produce the originals.
Yes, he has the original with him.
Original copy.
He has the original with. No, we don't want it. He has the original with him.
That is our statement, Lordship.
Okay, now the originals are not with you. How did you sanction the loan?
Whether we had the original copy, whether at the time of assignment.
No. Till the loan is cleared, the policy is never reassigned. We all have had occasions to have loans. So if the policy is not there, what charge do you have?
I can't comment on that because that instruction I don't have, Lordship, whether that.
Mr. Saraf,
copy-
a commercial expert man, can a bank or an LIC assign a loan, sanction a loan without assignment of the policy? Never. Policy assigned.
IC's cases, they have assigned it.
Where?
They have stated that this is assignment they are saying. That's it, Mike. That's
That bank transfer.
Yeah, that is assignment they are saying. And assignment has to be in terms of section 38 of the Insurance Act, my lord.
What does section 38 say?
A transfer, assignment of a policy of insurance wholly or in part, whether with or without consideration, may be made only by an endorsement upon the policy itself or by a separate instrument signed in either case by the transferor or by his assigner or his duly authorized agent and and attested by at least one witness. If they have that assignment, other day Central Bank was saying, that I have also got the original copy. Where is that
Who
assignment?
is appearing? Get the original copies tomorrow. Canara Bank, 4,80,000. Get the original documents, your whole loan file. Tomorrow. Or tomorrow will not be. Monday. Monday not again. Tuesday ko idea. Miss Chakravarti will have it on Tuesday. This is the only point.
Yes, ma'am. The violation of section 38, I am alleging that how you can make assignment like that.
If you can't show that her cases of fraud, if you can't show that this was done in the manner required,
That's it, ma'am.
her stand,
That's my cases.
her stands vindicated. Subject to what happens in the.
It has been credited. That was not denied, Lordship.
Oh, Central Bank is a party here. Who is appearing? Central Bank, who is appearing?
In my affidavit, Lordships, if not,
And you never were a banker in Central Bank.
B, Lordships.
Lord, I have stated in this petition, all this, my PAN card, my electricity bill, everything.
Everything was forged.
And everything was brought to the notice of LIC by visiting their office.
May I add 2 points, Lordship? B, Lordships, this is a.
Where? Annex
my
B of?
affidavit, Lordships.
Huh?
Page 12 of my affidavit. Regarding
The
the
photograph is yours.
No.
photographs,
No, no.
I can
11,
demonstrate.
11.
I can demonstrate. It is yours.
This
Huh?
photograph is not yours.
My lord, I know this person
Page
since my
58.
childhood. This is not his photograph.
58.
I have stated in my affidavit also.
58.
And,
58.
Page 50.
58. Ashutosh Chaudhary. 58 of the affidavit filed by LIC. Oh, Mr. Kundu, this is only with regard to credit of 13 lakhs. No dispute on that.
Yes.
Whether that by itself will absolve you when the very
Maybe,
account is in
Lordship,
doubt.
maybe, but that is not denied.
This is not. applicable.
Have you set somewhere anywhere? Any affidavit by
Yes,
the
yes, rejoined
Central Bank?
affidavit.
Any affidavit by the Central Bank authorities?
Canara Bank filed one affidavit. I have filed my rejoinder. And in rejoinder, I have stated all this.
Central Bank is not represented.
Yes.
You are appearing for Central Bank also. But you have taken notice on respond number 7 also. 5 and 6. On the prayer of the learned, prayer of Mr. M. Sharma, Learned Council for 5 and 6.
My lord, Wakalandama only for
We don't know. So after the matter was brought to this notice of this court on 1/5/25 of an FR being submitted, you filed a Naraji petition.
FIR, Lordship, one by the complainants, in the two FIR, Lordship, complaints submitted by even in the 23, Lordship.
Into our
Naraji
knowledge
petition
during-
has been given just
Because this,
few days back, Lordship.
the FR has come to our knowledge during the course of
this
proceedings as
proceeding,
produced by the government advocate.
Hey, Ukalatnama court theke sir. Mr. M. Sharma, appearing for both respondent number 5 and 6, submitted that affidavits have been filed on behalf of both the respondents. But no affidavit in respect of respondent number 6 is received by the section. A reference order date 28/2. Madam, you have been taking stand here in the court that you are also representing respondent number 6, Mr. Sharma. Let us get hold of Mr. Sharma. We'll also have to have central bank before us. That too. Ask Mr. Sharma to be here. Okay. We'll not trouble you. We are not passing any orders today. We only one day, you get the originals, we'll pass the order. You get the originals of your loan file and the proposal, the sanction, everything, you bring it on record. And the central bank and the Canara Bank will also bring it on record. We'll see. And we may even require the CM Vigilance Cell or the special cell here to make an investigation. Right. But if we are satisfied in the meantime that he has been denied, we would like you to make submissions as to whether in the interim we can direct for the policy to be held in force in favor of the petitioner. Make that submissions also.
FSL is not required. Your bare eyes, my lord, can make out that original document, what
I'm
they
not
are
on
saying.
that. I'm not on that. When if we direct for a fresh investigation in the matter, whether in the interim we can direct that the policy be held to be in your name, we dehouse this,
To get some
dehouse
petition.
this, you make your submissions on that. Make your submission with decisions. Yes. Where is Mr. Das? Yes, you
But if I may point out, Milord,
were supposed to bring on record those final orders.
they have given me a instructions. They are yet to file their affidavit.
You want an affidavit from them?
Yes, Milord.
Okay. This court on the last date of
There is a
listing,
reason, Milord.
this court on the last date of listing had required the learned government advocate appearing for the state respondents to furnish a copy of the instructions received by him to the learned counsel for the petitioner so as to enable him to make his submissions in the matter. The said course of action was adopted in view of the fact that in the present proceedings, the claim made by the petitioner is for release of ex gratia payments. The petitioner had also undertaken or was also given liberty to bring on record any additional material in support of his submissions, inasmuch as the petitioner had submitted that he would file the final orders passed by the trial courts in the criminal proceedings involved in the present proceedings. Today, Mr. Singha, Learned Counsel, appearing for the petitioner, has submitted that the respondents herein be required to file an affidavit. Also, accepting the submission made by Mr. Singha in the matter, this court directs Mr. N. Goswami to file his affidavit in the matter on or before the next date of listing. Mr. Borpujari, R. Borpujari, Learned Standing Counsel, Finance, appearing in the matter, is also at liberty to file revenue to file an affidavit if so advised. Also, registry to list this matters again after 6 weeks, along with the affidavits filed by the respondents in the matter. I wanted to give you that relief by shortcutting the procedure. Now you want the procedure to be followed, we'll follow.
I am also helping.
We'll follow. We'll follow. That you do. You file an affidavit to that effect. Let Mr. Sinha object to that. Otherwise, we'll not hear you.
Lordship, item 20, I beg to appear virtually in item 20, Lordships.
Yes.
Lordship, this matter relates to GST, Lordships. The issue is, Lordships, for 2017-18.
Is it ready for final disposal?
Lordship, it's a very short issue. It's a very short issue, Lordships.
Today, because we will not be here tomorrow after 1 p.m. So there is a long list, something. Give me a date, we'll fix it for final disposal.
Lordships will take this on Tuesdays or Thursdays, I believe, Lordships.
Next week, tied up. The week thereafter, any date.
Lordship, 19th, can we have it on 19th?
19th,
21st, Lordship.
They stated that the pleadings in the matter is complete. We'll have it on a hearing day so that we can have some time. 19th.
21st is a Thursday, Lordship.
21st, done. As agreed to by the Learned Counsel for the parties, raised to list this matter for admission hearing on 21/8/2025. An endeavor would be made to dispose of the matter on the next date of listing.
Much obliged. Grateful to your Lords. Much obliged.
Covered matter, Lordship. Of subsequent amendments brought on the statute book, the demand is no longer sustainable. Of 17, 18, 21, 22, Lordship.
Covered. 17, 2017,
27,
17, 2017.
we were given, but
The amendment was given effect from
yes, Lordship, it is correct.
26/4/24. Hmm. 26,
424.
24.
page 59.
Been effect from
49,
27,
Lordship.
24,
Just a minute. Page 40?
49.
49.
Okay.
The relevant part will be page 52, Lordship, para 5.4,
This is for the period.
1819, Lordship.
49.
Hmm.
Page 52, para 5.4 on the bottom, Lordship. The returns were filed 3 days late.
So in terms of the unamended provisions of 16/4,
It was
You were-
3 days late.
3 days late, so you were not given.
Subsequently, the 16.5 was brought on the
No.
statute book by Finance Act 2024, Lordship. And they said that for year 17, 18, 18, 19 and
Till November 21,
30th November
21.
2021.
And you had submitted your returns on
23, 10, 19, Lordship.
Order was passed.
Mr. Gal, before the division bench, similar matters in and out were being disposed of. You were appearing.
Yes, Lordship, but the
What is the issue difference here?
here, Lordship, in that case, Lordship, no order was passed. The provision of section 16.
Now, after 16/5 has come in, 16/4, the bar has been removed, at least for the 4 financial years. And what is to be filed within that period has now been extended till November. So
21.
admittedly, he has filed under the unamended 16/4 or the unamended Finance Act. He had filed it 3 days late, so he was not eligible to take the input tax credit. Now, after the amendment has come and the amendment has been given a retrospective effect. So, that filing will now be permissible till November.
Lordship.
Yes, Lordship, that is correct.
Then what is the problem? Huh? Okay, appealable order. Okay, done.
Here, there is another defect.
Hmm.
Come to page 51.
51.
3.1.
Hmm.
Document in support of. Next, the reply was submitted by him.
So that is a ground wherein leaving aside everything else, bringing in Whirlpool,
Lordship.
I can always exercise my jurisdiction.
Lordship, here, Lordship. Law was amended.
Both cases, Lordship, the order does not survive. Because of 16.5 as well as for non-consideration of the
Yes,
reply.
Lordship, it is a
Can be set aside and remanded back, Lordship. There will be no further proceedings. We are sure about it. If it is remanded back, there will be no further proceedings.
In this order that you have given me, when was the return filed?
Within the 30th November 2021.
No.
Lordship.
The order was passed here in the order that you have given me.
Lordship,
Maina Devi Sohoria.
Lordship.
When was the
The common order passed for so many cases, Lordship, so perhaps it was.
No, where, what is the date of your show cause notice?
So my show cause notice, Lordship, it is 27/12/23. In this case.
27/12/23.
In that case, it was 6/12/23.
Now, in this case, when was the return filed?
The return was filed on 23. 1 second, Lordship. 23/10/19.
And the amendment had come, they notified on
9/24.
on 27.
24 with effect
So-
from 1/7/17.
So, Mr. Cal, your case is that the amendment, okay, has retrospective effect, but having come after the date of deposit, he should not be given any benefit there. But have you filed an appeal against this order? 1764/2024. Why?
Is relating to state order.
Be that as it may, it's under the Finance Act only,
Lordship.
and the state government had not issued any notification. But that amendment, Mr. Kal, is retrospective. 5 clarifies 4.
When the order was passed, there
Fine, need not be. But that order having a retrospective effect, show me that it will not be applicable to him.
order was passed.
Fine. That order to that extent is perfectly fine. If 5 had not been incorporated, that order would have held the field and he could have gone up on appeal, whatever it is, on merits, not on technicality. Today, it's a technical plea. The only ground why he was not given the input tax credit was that he had not filed it within the time prescribed. He had filed it 3 days late. 16/4 was there, gone. So that amount was taken away. Today he claims that because of 16/5, that amount of input tax credit that I have claimed would be liable to be paid to me because the date of submission of returns has been extended to 21, and admittedly I had filed it in 19 itself.
Lordship. Lordship.
Protect the
What we do is we can interfere with this order, remand it back. This was passed by the assessing officer. We can remand it back to the assessing officer to pass a fresh order.
And in Maina Devi Choradia, CGST was also a party, Lordship.
Huh?
In Maina Devi Choradia,
He was a
he
party.
was also a party.
But Mr. D. Saraf, just see if there is something required, tell me.
Lordship. Lordship.
Learned counsel for the petitioner also heard Mr. S.C. Kal, Learned Standing Counsel, Central Goods and Service Tax Department. FOSO. The petitioner in the present proceeding has presented a challenge to an order dated 26/4/2024, rejecting his claim for availment of input tax credit bracketed ITC amounting to rupees 79,05,895 for the period 2018-19, right?
Lordship.
On the ground that the returns, GSTR-3B returns for the said financial year was filed on 23/10/2019, when the due date for filing of such claim was on 20/10/2019, and accordingly applying the provisions of Section 16(4) of the GST Act 2000, IGST Act 2017, the said claim was so rejected. Also, the Learned Counsel for the petitioner has submitted that Full stop. Mr. Cal, Learned Counsel for the, full stop. At this stage, it is to be noted that the provisions of Section 16 of the CGST Act 2017, as it stood before its amendment, provides for the eligibility and conditions for taking input tax credit for the registered person. Section 16(4) of the CGST Act 2017 mandates, provides as under page 9, A to A. Also, amendment was effected to the Finance Act by way of the Finance and bracketed number 2 bracket over Act of 2024, and subsections 5 and 6 were incorporated in section 16 of the Act. Also, the provisions of subsection 5 and 6 as incorporated by the said amendment being relevant is extracted herein below. B to B. Also, the said amendment was so notified by notification number 17/2024 with effect from 27/9/2024. Also, our episode para 20. Wrongan যেটো দিছো নালাগে। What is the show cause number?
Show cause lordship,
Number?
in this case, it
A
will be
show
page-
cause notice, demand come show cause notice.
Page 33 lordship.
33. So, according A to Pishana, my ex bulema so, accordingly, in view of the amended provisions of section 16, this court, more particularly subsection 5 thereof, this court proceeds to set aside the impugned order dated 26/4/2024. Also, having interfered with the order dated 26/4/2024, the matter is remanded to the Assistant Commissioner, Central Goods and Service Tax, Dibrugarh Division, for passing a fresh order in the matter after providing fresh order in the matter if show cause notice to set aside video. By issuing a fresh show cause notice to the petitioner and thereafter affording to him a due opportunity of hearing. Full stop. With the above directions, observations and directions, the present writ petition stands disposed of. Hope I have not left out anything.
Lordship had recorded AGST, it will be CGST.
CGST.
Then the notification of amendment lordship has stated with effect from 24, it will be dated with 24 with effect from 1/7/17.
Oh, but dated so and so, I'll make the correction.
Sure.
Dated so and so, in notification dated so and so.
It will take care lordship.
No, I have asked you to issue a notice if
So it
required.
might not be
You
necessary.
issue a notice, then he will not come, you do whatever you want.
Necessary, he will issue.
No. I have asked him to issue a notice to him. He'll issue a notice then on that day. Trying to learn these things, so help that's why the help is required.
Deeply obliged, Lordship.
That is it. He's- Huh? Yeah. Yes. No, it's okay. That's why we sent for you. We want you now here. What happened?
I have been given a copy of an instruction.
Hmm. So now this girl should not suffer. This girl should not suffer any further. So I'm not closing the petition, I'm keeping it.
Yes, Your Lordship will keep it.
You issue the PPO, we'll close it. When? 2 weeks. Done. Reasonable. Your name? K. Zaman, learned. Heard Mr. AFNU Mullah, learned. And Mr. K. Zaman, learned counsel for the petitioner. Also heard Mr. D. Bachchaji, learned standing counsel, Accountant General Assam. Also, Mr. Bachchaji submits that the 2 halves of the PPO issued in respect of the father of the petitioner has been returned, as per his instruction, has been returned by the jurisdictional treasury officer. Also, he submits that the matter would now be processed for issuance of the family pension of the, for disposal of the family pension of the petitioner within a further period of 2 weeks from today. Also, he submits that by the next date of listing, there will be a fresh PPO issue.
I'll just make one submission. I'm very sorry I'm interrupting.
No, please. I don't want anything wrong to go in.
Given a letter which says that been sent. I do not know what has been sent.
Okay. Heard Mr. Soblikhila. Mr. D. Bachchaji submits, Mr. R. Borpujari, learned counsel for the petitioner. For the standing counsel finance department has on instruction submitted that the both halves of the PPO issued to the father of the petitioner has been sent to the office of the principal accountant general, A&E Assam, by the treasury officer Dhubri on 25/7/2025. Also, Mr. Bachchaji submits that he has no instructions with regard to the receipt of such PPOs by the office of the principal accountant general bracketed A&E Assam. Also, raised it to list this matter again on 18/8/2025, on which date Mr. Bachchaji shall apprise this court as to whether the 2 halves of the PPOs forwarded by the jurisdictional treasury officer on 25/7/2025 has been received by the office of the principal accountant general bracketed A&E Assam. It is provided that in the event the said 2 PPOs have been received, the matter be expeditiously processed by the office of the principal accountant general bracketed A&E Assam, and a fresh PPO as required be issued to the petitioner at the shortest possible duration. So on the next date of listing, in the event the PPOs have been received by the office of the AG Assam, AG A&E Assam, comma, Mr. Bachchaji shall also apprise this court about the stage of processing of the said proposal pertaining for disbursal of pension to the petitioner. Also, a copy of the communication dated 25/7/2025 furnished by Mr. R. Borpujari is kept on record and marked as X. Now that you have it, give it. Now for delay, if there is, we will now come back.
I've given it.
Now that thing is flying somewhere. That has to reach him. Huh? The matter is flying now from Treasury Dhubri to Guwahati. So that's why I restrained myself from passing any orders today. Okay, done. But Mr. Bachaji, impress upon your officers if they have received it to release it to her. It's abnormally delayed.
Done previously.
Okay, thank you. Yes,
Matter, my lord, instruction was called.
yes.
I think that 20 lakhs rupees, but
File an affidavit to that effect on by Monday, Wednesday. Show me the instruction. You can dispose of the repetition. Heard Mr. M.A.I. Hussain, Learned Counsel for the petitioner. Also heard Mr. N. Goswami, Learned Government Advocate, appearing for the state respondents. The for the respondents number 1 to 5. Also, the petitioner, by way of instituting the present proceeding, has prayed for a direct has prayed for interference by this court with a communication dated 2/3/2024 issued by the investigating officer, Crime Branch Police Station, Panboza, to the branch manager, AU Small Finance Bank, Guwahati branch, with a request to freeze the debit and credit facility of the bank accounts mentioned therein, including the account. Where is your account here?
And page number 42/6.
Including the account operated by the firm of the petitioner, that is Rudra Enterprises.
For infrastructure.
Rudra. In Rudra Enterprises, it is here.
It's in the type copy, my lord, wrongly it was,
Oh, you have
42.
typed it out wrong. Rudra Infrastructure.
42 page number, my lord.
Rudra Infrastructure. Also, the pleadings brought on record in the matter after issuance of notice by this court to the respondents reveal that the said action was so required to be instituted in pursuance to the materials coming on record was required to be so issued in view of the materials coming on record in pursuance of the investigation conducted in Crime Branch PS case number 5/2024. Also, it is seen that where was that details given? Somewhere here it was given. It is seen that an amount of rupees. What was the total amount taken from that informant?
That informant, my lord, the total amount is 10 crore 40 lakhs.
Where do I get it?
It is in the FIR, my lord, it was, details has been written.
Where is it?
Where is it? Page number 33, my lord. Started from 37, my lord.
Hmm.
Various installment it was given to the random accused, my lord. Twenty-nine numbers of demand drafts has been given.
An amount of rupees. Just give me that total figure here. Give it to him.
10 crore 40 lakhs.
10 crore, approximately 10
10
crore,
crore
40 lakhs, 40 lakhs was fraudulently taken from the informant in the said criminal case in the name of issuance to him of lifting of rice, edible food items and animal fodder from FCI, from Food Corporation of India. Also, the informant had therein submitted that the amount so remitted by him to the accused persons therein was so deposited in an account which was so opened in the name of General Manager FCI, Patna, Bihar. Right? So, during the course of the investigation, the police had come to it had come to light that from the amount deposited in the said from the account opened in the name of the General Manager FCI, and wherein the informant had deposited money, transfers were made therefrom to various accounts at various places all over the country. One of the accounts to which the amount therefrom was transferred was the account operated by the petitioner's firm, that is Rudra Infrastructure, with the AU Small Finance Bank, its Guwahati branch. No, this amount is at Mohali.
But the notice was issued to the Guwahati branch.
Or at Mohali branch. Full stop. The amount so transferred to the petitioner's account from the proceeds which have now been denoted as to being proceeds of crime amounts to rupees 20 lakhs. Full stop. That on 31/7/2025, next, when this matter was taken up for consideration, this court had required. The petitioner has instituted the present proceeding inasmuch as he has now been restrained from operating the said account, which he contends to be required to be operated in connection with his business operations, in connection with the business operations of his said firm. The said account not being permitted to be operated, the petitioner submits that his business has suffered for the same. It is also projected by the petitioner that in addition to the amount of rupees 20 lakhs, which was credited to his account from the account created in the name of the General Manager FCI and indicated herein above, there is a further amounts which has been deposited by him from proceeds received on account of his bona fide business transactions. Also, this court on the last date of listing had required the learned government advocate to receive instructions as to the stage of the investigation and as to what time would be so required to complete the same. Also, today, Mr. N. Goswami, learned counsel for the learned government advocate appearing for the respondents number 1 to 5, has furnished a copy of the instructions received by him from the senior superintendent of police Kachar, Silchar. In the said instruction, it has been highlighted that the petitioner is one of the recipient of the fraud and duped amount, and rupees 20 lakhs out of the crime proceeds was deposited in his bank account. Also, it is further highlighted that the trail of the transaction and the persons involved in the transactions are under investigation. However, the investigation could not progress as desires due to inability to trace the person involved as per the addresses mentioned in the KYC documents which were provided by the bank authorities. The senior superintendent of police has further in the said communication, in the said instruction, stated that the petitioner may be allowed to operate the bank account in question. However, the amount of rupees 20 lakh deposited therein, which is the proceed of crime and under investigation, be not permitted to be utilized by the petitioner. Also, in view of the said disclosure made by the senior superintendent of police Kachar in the instructions dated 6/8/2025 furnished by Mr. N. Goswami, this court is of the considered view that the present writ petition be not detained any further for consideration and can be disposed of with the following directions. Also, the petitioner is permitted to operate his bank account number so-and-so opened with the so-and-so branch, so-and-so bank branch. You give me this number, branch, the bank name, branch name. Also, however, the AU Small Finance Bank, more particularly the authorities of this Mohali branch of the said bank, Mohali branch of the said bank, shall ensure that the petitioner in no way utilizes rupees 20 lakhs deposited in his account. In other words, till further clearance is received from the investigating agency, an amount of rupees 20 lakhs shall always remain in the account of the petitioner. Also, the petitioner herein, while being permitted to operate his said bank account, is also cautioned from utilizing the, from bringing the balance in the said account to below 20 lakhs at any point of time. In the event the petitioner, during the operation of his account, reduces his balance therein to below 20 lakhs, the bank authorities shall immediately freeze further operation of the said account, and the liberty granted to this petitioner while this order would not be further operable under such circumstances. Anything more required? Also, with the above observation, also, the branch manager, branch head of AU Small Bank, Mohali branch, shall every month transmit to the investigating officer of, what is that case number? Of dash case number, the transactions, the statement, monthly statement of the transactions carried out by the firm of the petitioner in the said account. With the above observations and directions, the present with petition stands disposed of. A copy of the so-and-so is marked, kept in the record and marked as X for purpose of identification. itu dilon তাৰপিছত বাকিখিনি শুন এই 1 নম্বৰটো তাৰপিছত টাইম বিং মাতিবা Yes, Mr. Chaudhary, have you got the conditions?
Yes, Lordship, I have corrected, my lord.
Aburi, কলম গিটা দিব এইটো লৈ লওক Which is that condition?
Clause 7(1). Common, my lord. Clause 7.1. That is mandatory. Obtaining counter, I have to submit the bid. I was prevented because non-signing of these counters. The issue. On issuance of countersign, my lord,
The background of the photo, it is not.
Okay.
Both photographs, different persons are.
Both are not the petitioner. File an affidavit. Anything more, Mr.
no, my lord, when I file a complaint before the respondent number 2, that has not asked any question to respondent number 2.
Now we will
Why?
ask.
Why? Yes.
We will ask. We will ask. Don't
Paragraph
worry.
6, my lord.
Heard Mr. K. Bhuiyan, Learned Counsel for the petitioner. Also heard Mr. B. Chaudhary, Learned Standing Counsel, Public Works Roads Department. Appearing, Public Works Department. Issue notice, returnable. It will take you 2 weeks to file an affidavit. 2 weeks. Also, Mr. Chaudhary accepts notice on behalf of the respondents, all the respondents. Accordingly, no formal notice is required to be issued. Also, the Learned Counsel for the petitioner shall serve requisite extra copies of the writ petition to the Learned Counsel for the respondents within 2 days from today. Also, the Learned Counsel for the petitioner has prayed for an interim direction. Also, the parties to the proceeding have been heard. Mr. K. Bhuiyan, the Learned Counsel for the petitioner, by referring to the provisions of Clause 7 of the
7.1.
Clause 7 of the tender conditions, more particularly Clause 7.1 thereof, has submitted that a mandatory site visit certificate along with a verification from the concerned engineer authenticating his visit to the site of work is mandatory to be submitted along with the bid. The petitioner herein contends that he, upon completion of the site visit, had approached the respondent number 3
On
for
28,
along with an application dated 28/7/2025, comma, which was received by the respondent number 3 on 28/7 over there, which was received by the respondent number 3 on 29/7/2025. However, the site visit certificates enclosed thereto were not countersigned. Full stop. In absence of the counter signature being so made, the petitioner herein had approached the Chief Engineer, Public Works Roads Department, that is the respondent number 2, praying, raising a complaint in the matter against the executive concern, against the respondent number 3. Also, Mr. Bhuya has submitted that the certificate along with the photographs annexed thereto would go to reveal that the petitioner had visited the site of the 3 projects against which he intended to submit his visit.
Bill number Lordship 1 to 3.
Also, Mr. B. Chaudhary, Learned Counsel, was required to take his instructions in the matter. Accordingly, Mr. Chaudhary has received his instructions. Also, Mr. Chaudhary, basing on the instructions received, has submitted that the assertion made by the petitioner that he had visited the site of the projects is clearly perverse, inasmuch as the photographs enclosed to the communication dated 28/7/2025 is not of the petitioner, and the site as indicated therein is not the site wherein the projects are sought to be implemented. Projects which were tendered were sought to be implemented. Also, Mr. Chaudhary has submitted that the tender conditions as contained under clause 7.1, having required the bidder to visit the site and there being no contention raised in the present proceeding that the petitioner had not proceeded to the site, but the person who had proceeded to make the site verification was his authorized representative, comma, the respondent number 3 had not countersigned the certificates as enclosed to the said communication dated 28/7/2025. Also, the rival submissions having been considered, this court is of the considered view that the said matter would require a deeper examination. Accordingly, Mr. B. Chaudhary is directed to file an affidavit in the matter on or before 21/8/2025. Also, the prayer for interim relief as made by the petitioner in view of the rival submissions of the parties stands rejected at this stage. Also, registry to list this matter again on 29/8/2025. Full stop. Basing on the disclosures that would now be made in the affidavit to be filed by the petitioners and the rejoinder thereto by the respondents, this court on the next date of listing would consider taking up the present writ petition for final disposal.
Lord, interim sense of work order is to be stayed. Till next day.
Upor atal line likhiba. A submission submission. It is to be noted that the last date for submission of bids in pursuance to the NIT dated 9/7/2025 was on 31/7/2025. The present writ petition was filed by the petitioners on 4/8/2025, that is after the last date of the submission of bids in pursuance to the said NIT. You can go ahead. We'll see on the next date. If we find that you are been illegally deprived, it's not, our hands are not closed, we can compensate you. There is no problem. কাম কৰা এই ডাঙৰ মেৰি মাতি দিয়া মানে তুমি এইখিনি মাৰি দিয়া মেৰিয়াম বেকিং নহ'লে ল'বা নেকি হ'ব নালাগে থোৱা নালাগে ল'ব এই আইটো দিয়া Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Dury, Learned Counsel for the applicant, IAC 1557/2025. Also heard Mr. D. Nath, Learned Senior Government Advocate, appearing for all the opposite parties. Mr. S.S. Roy, Learned Counsel, appearing for the CGC, appearing for the respondent number 1, and Mr. D. Nath, Learned Senior Government Advocate, appearing for the respondents number 2, 3, and 4. Also, as consented to by the Learned Counsel for the parties, the present interlocutory application was taken up for final consideration and is being disposed by this order. Also, the applicant hearing as petitioner had instituted WPC number 1924/2025 being aggrieved by a tender notice inviting tender dated 26/3/2025 for selection and appointment of handling and transport contractor for transportation of food grains under NFSA-2013 for the district of Tinsukia for the financial year 2025-2026. The contention raised by the petitioner in the writ petition was that the engagement of a private contractor for transportation of food grains under the food grains is contrary to the provisions of the Targeted Public Distribution System (Control) Order 2015, more particularly clause para 7(1) thereof read with para 2(G). Also, this court, according to bench of this court, on considering the issues arising in the matter, was pleased while order dated 7/4/2025, while issuing notice to pass the following. Was pleased to direct that the notice inviting tender dated 26/3/2025 be not acted upon till the next returnable date. For the purpose of passing of the said interim direction, this court had noted the submission of the Learned Senior Counsel of the petitioner to the effect that the notice inviting tender in question was issued in violation of the provisions of clause 2(G) of the Targeted Public Distribution System bracket Control Order 2015 bracket hereinafter referred to as the Order of 2015. Also, the petitioners have thereafter instituted the present interlocutory application inter alia, contending that the District Commissioner Tinsukia, in pursuance to the directions, in pursuance to the interim order passed in the connected writ petition, had engaged a private transporter for transportation of the food grains from the godown of the Food Corporation of India to the fair price shops. Also, Mr. K.N. Chaudhary, Learned Counsel for the petitioner, by taking this court through the interim directions passed wide the order dated. Yeah, I got order to 24. Okay. Seven 2025 has submitted that this court, having arrived at a prima facie conclusion, as a prima facie satisfaction that the NIT in question was NIT in question issued for engagement of transporters was so issued in clear violation of the provisions of clause 2G of the said order of 2015, comma, the district commissioner Tinsukia, it was not permissible for the district commissioner Tinsukia to perpetuate the illegality as contained in the said NIT by engaging a private contractor for transportation of the food grains involved during the pendency of the said writ petition. Mr. Chaudhary, by referring to the pleadings brought on record in the interlocutory application, has submitted that the cooperative societies were being permitted to take to make the transportation of the food grains involved from the Food Corporation of India outlet to the fair price shops. However, the same was so stopped in the year 2000. Just stopped in the year 2015. Mr. Nutt, the private system came in 2015. After 2015. Also, Mr. Chaudhary has submitted that the petitioner, along with other similarly situated cooperative societies, had approached this court by way of instituting writ petitions. Also, a coordinate bench of this court, wide judgment and order dated 21/9/2017, passed in WPC number passed in 6647/2015 and other analogous matters, had held therein that in terms of the provisions of clause 2G of the order of 2015, a private party is not permissible to engage a private party in the matter of lifting of food grains. Also, he has further highlighted that the coordinate bench in the said judgment had also noticed the provisions of clause 2G and the definition of authorized agency existing therein to not, and held that the said expression does not include a private contractor. Mr. Chaudhary, by referring to the provisions of para 7, clause jot koisu para goidiba. Para 7 of the said order, order of 2015 has submitted that the same mandates the state government to lift food grains from the designated depots of the Food Corporation India only through its authorized agency. The term apostrophe authorized agency over is defined under the defined under the provisions of para 2 bracketed G, wherein it is contended that the said term would mean the concerned department of the state government or a body corporate or a company owned by it or a cooperative society. Mr. Chaudhary has submitted that the provisions of the order of 2015 having been so framed under the provisions by invoking the provisions of Section 3 of the Essential Commodities Act 1955 and para 717 bracketed 1, para 7.1 having mandated that the state government shall lift the food grains only through its authorized agency, and the definition as provided for the term authorized agency under para 2 bracketed G also in being inclusive of a cooperative society, comma, the tender process under challenge in the connected writ petition being kept in abeyance by this court, comma, it is the district commissioner ought to have permitted the petitioner cooperative society to lift the food grains from the designated depot of the Food Corporation of India for transportation to the fair price shops. Mr. Chaudhary has submitted that the coordinate bench of this court in the said judgment and order dated 21/9/2017 had permitted the state government to implement the steps as initiated by it for transportation of the food grains in terms of clause 7 bracketed 11 of the order of 2015. He has further submitted that in the said judgment, this court was considering the issue arising before it considering the issue arising before it from the standpoint of a cooperative society. So the coordinate bench in the said judgment, by noticing that the cooperative societies under the provisions of the Assam, what he called it, Assam Food Control Order, 1982, under the DSO 82 order, 1982 order, comma, only permits the cooperative society to for distribution of the food grains and not for transportation thereof. So, it is, Mr. Chaudhary submits that it is on the basis of the set conclusion drawn by the coordinate bench that the scheme as prepared by the steps as taken by the state respondents under para 7 of 7 bracketed 11 of the order of 2015 was so permitted to be continued. Mr. Chaudhary has further submitted that the said judgment and order dated so and so 21/9/2017 passed by the coordinate bench in so and so was assailed by similarly situated cooperative societies, and the division bench had permitted the appellant cooperative societies to continue to lift and distribute the food grains from the designated depots. Also, Mr. Chaudhary has fairly submitted that the petitioner herein had not preferred any appeal in the matter against the orders passed in the writ petition instituted by it. Full stop. That's right, it don't happen. Full stop. In view of the above submission, Mr. Chaudhary, full stop. In the above premises, Mr. Chaudhary submits that the alternative arrangement, the ad hoc arrangement made by the district commissioner for having the food grains involved transported by way of engaging a private contractor would require an interference from this court with a further direction to the district commissioner Tinsukia to permit the petitioner society to effect the transportation of the food grains involved pending disposal of the connected with petition, that is WPC number 1924/2025. Per contra, Mr. D. Nath, Learned Counsel for the Learned Senior Government Advocate, appearing for the respondents number 2 to 5, has submitted that the coordinate bench of this court, while the judgment and order dated 21/9/2017, having allowed the scheme formulated by the state respondents under 711 for the purpose of transportation of food grains from the designated depot of the Food Corporation of India to the fair price shops, and the same having envisaged engagement of a private contractor for such transportation, there exists no error on the part of the district commissioner Tinsukia in engaging a private contractor to carry out the transportation works involved in the matter. Also, Mr. Nath has submitted that there being a clear finding recorded by the coordinate bench of this court, while the said judgment and order dated so and so, to the effect that the cooperative societies, in view of the scope and ambit of the license issued to them, being not entitled to carry out transportation works, the prayer of the applicant for being authorized to carry out the transportation works would not mandate an acceptance of this court. Mr. Nath has further submitted that the state having formulated a policy under the provisions of section para 7 bracketed 11 for the purpose of transportation of food grains, and the same having been so done, keeping in view the interest of the beneficiaries of the scheme involved, such scheme prepared by the state respondents would not mandate interference from this court. So, Mr. Nath has further submitted that the applicants in the present writ petition has not demonstrated any right conferred upon them to continue to be authorized with the transportation work of the food grains involved, in exclusion to the other modes that may be resorted to by the state in the matter. Anything more? Mr. Nath has submitted that similar grievance as raised in the connected writ petition did not find favor with the coordinate bench of this court, and the prayer so made was rejected. He has in this connection referred to the judgment dated 4/12/2018 passed by a coordinate bench of this court in WPC number 7255/2017 and other 7255/2017. So and so. Anything more? Nothing? So, in the above premises, Mr. Nath submits that the prayer made by the petitioner for an interference with the system put in place for transportation of the food grains involved by engaging a private contractor would not mandate an acceptance of this court. He has further submitted that the prayer of the petitioner for being authorized or being permitted to transport the food grains involved should not also mandate an acceptance of this court. I've heard the learned counsel for the parties and also perused the materials available on record. At the outset, it is to be noted that the present order is being passed only in connection with the grievance raised in the present interlocutory application. Full stop. The petition, as noticed herein above, by raising a grievance with regard to the violation of the provisions of the order of 2015, had approached this court by way of the connected writ petition, assailing the tender notice dated 26/3/2025. Also, as noticed herein above, the grievance of the petitioner, as can be culled out from the submissions of Mr. K. N. Chaudhary, learned senior counsel for the petitioner, as well as from the pleadings brought on record, is to the effect that the provisions of section 7(1) or para 7(1) of the order of 2015 mandates that the state government shall lift food grains from the designated depot of the corporation only through its authorized agency. The term authorized agency has been defined under para 2G of the said order of 2015 to mean a concerned department of the state government or a body corporate or a company owned by it or a cooperative society. Also, it is to be noted that the order of 2015 was so formulated by invoking the provisions of Section 3 of the Essential Commodities Act 1955. Also, the orders of 2015, more particularly para 7(1) having 7(1), while permitting the state government concerned to lift the food grain, had also stipulated that such lifting can be only through its authorized agency. The definition of the term authorized agency also being in connection with the state government and a cooperative society, this court prima facie finds that a private contractor is not included within the term authorized agency. Also, the coordinate bench of this court, by the said judgment and order dated 21/9/2017, passed in WPC number 6647/2015, and also noticed the said position and had also noticed the definition of authorized agency as finding mentioned in clause in para 2 bracketed G of the order of 2015 and had drawn the following conclusions. Para 24, 25, 135 page. A perusal of the said conclusions would go to reveal that the definition of authorized agency does not include a private contractor. Also, this court, while passing the interim direction dated 7/4/2025, had so passed the same by noticing the definition of clause 2G of the said order of 2015. Also, at this stage, it is to be noted that although the coordinate bench, after having drawn the said conclusions, had proceeded to approve the scheme prepared by the state respondents for transportation of the food grains under para 7 bracketed 11 of the order of 2015, the said judgment is presently under consideration of the division bench of this court, amongst others, in writ appeal number 249/2018. Also, this court in the present order would not like to travel to examine as to whether the conclusions drawn by the coordinate bench is per inquirium to the provisions of the order of 2015. The said consideration would be so required to be made by the division bench in the proceedings of WA number 249/2018 and other analogous matters. Also, the said consideration would also be permissible to be so made in the, while considered to be made in WPC number 1924/2025 when the same is taken up for final disposal. This court only notes that the order dated 7/4/2025 has not been vacated till date, and the state also has not filed any application for vacation of the same, and the same continues to hold the field as on date. Also, in view of the fact that the tender issued for engagement of a private contractor having been kept in abeyance by this court in the connected writ petition, this court holds that the district commissioner Tinsukia could not have resorted to the same mode for transportation of the food grains, which mode has already been kept in abeyance by this court in the proceedings of the connected writ petition. Also, even if for the purpose of an ad hoc arrangement, the district commissioner Tinsukia, in the considered view of this court, could not have resorted to engagement of a private contractor for transportation of the food grains in violation of the provisions of section 7.1 read with section para 7.1 read with para 2G of the order of 2015. Also, accordingly, this court is of the prima facie view that the engagement of a private contractor for transportation of the food grains pending disposal of the connected writ petition being WPC number 1924/2025 would not be sustainable and would call for an interference. This court accordingly stays the engagement of a private contractor for transportation, accordingly stays the arrangement made by the District Commissioner Tinsukia for transportation of the food grains involved by way of engagement of a private contractor. Having drawn the above conclusion, this court would consider the prayer of the petitioner for being permitted to transport the food grains involved on the ground that the definition of authorized agency also includes within its ambit a cooperative society. Also, the said prayer of the petitioner at this stage would not mandate a consideration inasmuch as this court in the wide order dated 7/4/2025, while staying the operation of the tender notice inviting tender dated 26/3/2025 had not proceeded further to also permit the petitioner cooperative society to transport the food grains involved in the interregnum. So this court in the present interlocutory application would not venture to permit the petitioners of the applicant society to transport the food grains in question. The said issue would be considered in the connected writ petition at the time of its final disposal. Also, accordingly, the prayer made by the petitioner for being permitted, applicant for being permitted to transport the food grains involved from the from the designated depot of the Food Corporation India to the fair price shops stands rejected. Also, this court having interfered with the ad hoc arrangement made by the District Commissioner Tinsukia for transportation of the food grains involved by way of appointment of a private, by way of engaging a private contractor, this court notes that the transportation involved is of essential commodities and a sudden cessation of the transportation activities would have a serious consequence on the consumers of the said food grains who are the marginalized sections of the society. Also, appreciating the said aspect of the matter, this court provides that the district commissioner shall continue with the present arrangement of transportation of the private contractor for a further period of 1 month from today. Also, in the meanwhile, the district commissioner shall have the food grain, shall select an authorized agency for transportation of the food grains involved, and the agency so selected shall be one as specified in the provisions of para 2 bracketed G of the order of 2015. Also, with the above observations and directions, the present interlocutory application stands disposed of. I'll make some corrections here and there.
Pray, Lordship may give 2 months.
2 months time. 2 months time. Done. Some incorporations would be here of the provisions of law, and some more, 1 or 2 paragraphs may be incorporated. But tenor would be this only. Interlocutory application to this one, writ petition at least, raised Mr. Nath, Learned Counsel for the Learned Senior Government Advocate, submits that he be granted 6 weeks time to file his affidavit in the matter. Also, the petitioner may thereafter bring on record its rejoinder to the affidavit filed by the respondents, raised it to list this matter again after 2 months on a date to be fixed by. आराम से हमारा मुख दिले हो उनका. Yes, Mr. Gogoi. No, I only wanted, when did you take that decision? Because Mr. Khan's further case is that the communication was issued on 13. 13. 1320,
Yes.
on that day itself, there was a list published, select list published, or there was appointment made. What?
On that date, no.
Then?
Two select list was published on the same date, 13/3/2024. In respect of media expert, that has,
That is before 1310.
before 1310. They were appointed,
Media persons were appointed.
I have annexed that order.
So, if this is the basis, cancel everything, he'll be satisfied. Here it is said, cancel everything. Cancel the engagements made. All. No, that doesn't make a, see, after following due procedure, take immediate steps to cancel the engagements made recently, as well as any ongoing recruitment process where the reservation norms have not been adhered to. Thereafter, NHM may initiate steps to fill up the vacant posts. So this decision of yours by the competent authority envisages cancellation of all recent thing. That means all the posts that have been filled up in pursuance to the advertisement in question, gone. We are with you. You can't apply that selectively. And why was this delay from March to June in appointing them? Forget it. Here it is a concluded proceeding. The select list has come. No right to them. No right. But if the posts are there, the selection in question is not, there is no illegality in that selection process. This decision can only be prospective, cannot be retrospective.
These were the names of the.
I know. There is another list published of media experts.
Yes, I have annexed that.
Media experts, I
Yes.
found that.
107.
107. So these persons are also published on the same day,
Same day.
but they were appointed.
Appointment letter, that is 89.
They were appointed.
On 18/6.
18/6.
24.
So from 3 months, it was kept pending.
Persons were appointed.
Lekha. Mr. B. Gugoi, Learned Counsel, in terms of the queries raised by this court, why the order dated 14/7/2025 has placed on record a decision arrived at in the matter by the competent authority, which reveals that in view of the fact that a reservation policy is not followed in the matter of recruitment made by the NHM authorities, for cancellation of all engagements made recently, as well as for cancellation of the recruitment process that had not reached its logical conclusion. Also, it is seen that the select list wherein the names of the petitioners figure was published in the month of March 2023. However, nothing has been brought on record as to why the select list was not acted upon till the date of its cancellation. Wide day, page 67. Wide day, communication dated 13/10/2020, 13/10/2024. Also, the Learned Counsel for the petitioner has further highlighted that a select list published in the month of March 2023 for the posts of media expert, was acted upon, and the persons so selected were appointed in the month of June 2024. but the same benefit was not extended to the petitioners herein. Post thus, Mr. V. Gogoi, Learned Counsel for the petitioner, submits that he be granted a week's time to complete his instruction in the matter. Mr. Gogoi, on the next date of listing, shall apprise this court as to why the select list wherein the name of the petitioners figured, which was published in the month of March 2023, was not acted upon till October 2023. Also, further, as to why the select list prepared for various posts advertised, why the advertisement in question were selectively chosen for implementation. Also, further, as to whether there was any basis for a selective selection, selective selection of the posts wherein the selection process was taken to its logical conclusion. Also, the decision of the competent authority as placed on record requires cancellation of all engagement made recently wherein the provision of reservation was not provided for. In the present case, the advertisement in question having advertised various categories of hosts and recruitment to certain categories having been selectively permitted to be taken to its logical conclusion, Mr. Gogoi shall also apprise this court as to why, in the event the petitioner's selection was cancelled, the others so engaged were also not, others so appointed, the appointment of against other posts were also from the same, from the in pursuance to a recruitment process under the same advertisement was also not cancelled. Registry to list this matter again on. Give me a date. (21/8/2025). Full stop. It is provided that pendency of the present writ petition would not be a bar to the respondent authorities to reconsider their decision for cancellation of the select list wherein the names of the petitioners figure. Limited to the petitioners. If you can do that, we are hands off.
March 2023, your lordship has recorded, it will be
24, March 24 day. March 24. Select list March 24. You do it, come back, Mr. Khan will withdraw the writ petition. Otherwise, we'll have to go very deep into this. Yeah, you take it back.
Timing 16.
Mr. Sharma, you are appearing for 5 and 6. You have been projecting that all along.
No, your lordship.
In the order sheets, it's all 5 and 6, Mr. Sharma. You also appear for the, otherwise you also appear for the Central Bank of India lawyer. So,
Some cases I am being
okay, who is engaged in this case? No, Central Bank.
No, your lordship, I have no.
You are not representing Central Bank in any matter.
No, in other matters here.
You are there. Do one thing. We are engaging you on behalf of Central Bank. Receive your instructions on behalf of Central Bank. Get the complete dossier wherein this loan was sanctioned, along with the original policy. Without the original policy, you can't sanction a loan. No, sorry, Central Bank of India is not. I want the documents wherein the petitioner's account was created. There will be photograph and all. Get it.
Copy that we are having Canara Bank, your lordship.
Okay. You have a original policy copy. Okay.
The assignment of the LICI was also there.
Yes, madam.
My lord.
This will not be by the agency, police here. It has to go to CBI now.
Well, no, my lord, it doesn't have to go.
It doesn't have to.
Lordship will see that policy provided by my friend. At the top, you can make out the date of commencement is 2011, date of completion is also 2011.
Where?
The top column, my lord, that
One forwarded by, one furnished by Mr.
the one they are
Sharma.
claiming to be. Branch code is different, branch code doesn't match. Name date creation and the completion.
Premium due, your lordship. It is
Premium number is same. No, sorry, policy number is same.
Policy number, they have quoted same.
We'll get all the copies now. Where is the stamps in your paper, Ms. Chakraborty? The insurance stamps. The insurance stamps should be here. Every policy, when it is issued, they have an insurance stamp, blue colored.
It also is print code also doesn't match. And spelling of the name also is different.
This policy was taken out in 2011, right? Mr. Kundu, the bank authorities had sent this policy to you. And you have made an endorsement at the back. Huh? In 2017, right? Have you said that in your petition anyway? Where have you said that? Mr. Sharma, you have filed an affidavit?
Yes, sir.
What is your stand there? By Kapil Singh.
yes, S. Kapil Singh. Yes.
Where have you narrated this incident of the policy being given to you? 7.
Two letters, that is a policy.
Hmm? No, you gave me only this Belekibal letter. This is the thing. Okay. Petitioner is not a minor,
Is there is in my,
but what is this clause 2 here? Since the assignee would be who would be the assignee here? Assignee? You. You're not a minor. What is this? Assignee is a minor. It is avoidable. The guardian is got appointed to receive during the minority of the assigned necessary form in duplicate is enclosed. So and so, so and so. Sudipta Chaudhary's wife.
Chaudhary, everything. Gupta.
Sudipta Chaudhary, sorry. Madam, do one thing. You furnish a Xerox copy of this. Okay? To Mr. Kundu. Mr. Kundu, you also, Mr. Sharma, you also furnish a Xerox copy of this to Mr. Kundu. It's very easy. You have the format of the bank of the branch issuing this policy, right? Therein the branch code as well as the signatures of that relevant point of time. 5 December 2011. Some problem somewhere. Here the date is not there.
Verified, my lord. Branch code is wrong there.
Wrong. You got this copy.
Yes, my lord. From the LIC only I got it.
Okay. Here there is no date in the one given by Mr. Sharma. Issuing date is not there. Signature may be there. What is the branch code? 1. It is written here LIC of India Sakha SBO 1. You don't write SBO 1. SBO 1 is normally written by the banks. You write, how can there be a sub-branch office for LIC? LIC, there is no sub-branch. It's all branches, right? And trouble. Okay. Heard Ms. P. Chakraborty, Learned Counsel for the petitioner, also heard Mr. A. Kundu, Learned Counsel appearing for the Life Insurance Corporation respondent, that is the respondents number 1, 2, 3, 4. Also heard Mr. M. Sharma, Learned Counsel appearing for the respondent number 5. None has appeared for the respondent number 6. Also, during the course of deliberations today, the two policy documents were furnished were placed before this court, one by the petitioner and the other by Mr. M. Sharma, Learned Counsel for the respondent number 5. Both the documents have been shown to have been issued in favor of the petitioner herein by the concerned branch of the LIC. Also, however, in the document produced by Mr. Sharma, there is no date mention of the issuance of the same, while in the document produced by Ms. P. Chakraborty, Learned Counsel for the petitioner, it is seen that there is no insurance stamps affixed thereon. Ms. Chakraborty and Mr. M. Sharma are required to give a photocopy, a clear legible photocopy of the policies in their possession to Mr. Kundu. Mr. Kundu shall have the said policies verified from the branch involved and a certificate in this connection and an affidavit in this connection shall be filed by the concerned branch head. Also, The concerned branch head shall also produce for inspection by this court copies of similar policies issued approximate to the time the policy was so opened in the name of the petitioner herein. That is around December 2011. The branch head shall also indicate in his said affidavit the name of the branch manager holding the name of the incumbent holding the post of branch manager at the relevant point of time when the policy in question was so issued, as well as the name of the branch manager in office, senior branch manager in office, who had signed the assignment note on 8/3/2017. The said affidavit be filed on or before 27. Why? Silchar. Aita. On or before 28/8/2025. Registered to list this matter again on 1/9/2025. Complete copy. Complete copy, everything. Mr. Sharma, we will cross the bridge when we come. Let me get these details. We'll see then what to do. Because now the matter is beyond the scope. It has to either two-way out. One, civil court. Go and both of you go to the civil court and then. But before that, we want to be satisfied. Etu bhalke ghurai dibo. Etu Sharma, etu Chakraborty.
My lord,
Full stop. Further, as claimed by Mr. A. Kundu, as submitted by Mr. A. Kundu, the original. You said you had the original with you. You have said somewhere. Where have they said? You have not said. That Mr. Sharma is trying to. That is what Mr. Sharma is trying to put in your mouth.
under the act, my lord, even somebody assigns it, it is the duty of the LIC to ask this.
Madam, we'll come to the act. We will come to the rules. But first, let us see what it is.
For 5 lakhs rupees, I'll deposit 68 lakhs.
Madam, for 500 rupees, people are doing that. 5 lakhs is big amount. And if there is a fraud committed in the matter, either side, hats off. Hats off.
The solitary instance, my
No,
lord.
no, no, hats off.
This is not the solitary
Hats
instance.
off, I said. Something which I never contemplated before I read this brief yesterday night. We'll see. We'll have to come to a conclusion. Get me these details. Because, madam, one more thing is there. Policies of 2011. The wrong assignment is of 2017. Now, naturally, in an organization like LIC and all, you won't find a branch manager continuing from 2011 to 2017. If there are two different individuals who have done it, that gives certain amount of credence to that contention. That is what is worrying me.
My information is that officer, they have already taken.
Further, Mr. Kundu shall also, the branch head in his said affidavit shall also indicate as to whether on the anomaly with regard to the policies issued to in the name of the petitioner having come to light, what steps were taken by the LIC authorities in the matter. So, the said contention be supported by documentary evidences. Now come, we'll see. Today sometime is impossible.
We need to reply also, my lord, because they have.
As prayed for by the Learned Council for the parties, a registry to list this matter after 3 weeks on a date to be fixed by it. Parties are at liberty to complete their pleadings in the meanwhile.
An interim to be continued,
Interim is there.
my lord.
Okay, 1 week,
My lord, not 1 week, my lord.
2 weeks.
Yes, 2 weeks.
Or you have some urgency, you want to do, then we'll do. Where is the survey report? Survey report, survey report.
They have not given, my lord. That's what I want to reply, my lord. They make a, my lord, wrong submission, wrong affidavit, my lord. That's what I want to reply. And they never visited, my lord.
Okay, 2 weeks. Kabir. 2 weeks, make a mention, we'll have it.
Interim to be continued.
Interim order to continue till the next date of list.
First.
Yes, Mr.
Yes,
Burwa.
Your Lordship, there is
Huh.
long pending matter, my lord. Since 2012,
Hmm.
8 times round of litigation, my lord.
And it has come up on a very wrong day.
Yeah, yes, my lord. Only thing, my lord, is a matter relating with the establishment of brick lane, my lord. Lanes down, my lord, is impugn, the last impugn.
Where is the Council for the Pollution Control Board? Oh, you are there. You were missing these days, that's why I asked. Yes, what is your stand? What is your stand?
That thing, if those previous orders, so Lordship can find out in the writ petition that they have preferred. Prior to this writ petition, there was another writ petition. That finally the court has interfered and given a direction that a joint.
Here is the
Yes,
report.
so in that particular, I'm not talking about this immediate.
This one.
Prior to that. That point of time, the scientific explanation hasn't been given by the pollution board, and also the agriculture department's report was not missing.
Hmm.
So finally, again, a direction has been granted that in the presence of the scientific reports of all 4 stakeholders,
Hmm.
a decision arrived at. And finally, a decision was taken.
Then the
Now-
basing on that, they have now,
And that, after that order, now they have come before.
they have challenged this order.
That order to the extent that it has been passed by the additional deputy commissioner, not by the deputy commissioner.
No, it has been
So
passed by
Commissioner
the
Lordship,
deputy
once
commissioner.
The prayer portion also will find out it is only limited, very small periphery, where they have just said that this order has been passed by the ADC, which ought to have been by the deputy commissioner, because that is the authority before whom they are going to challenge. And now, in due course of this writ petition, subject has arisen, and whether it falls under that boundary of that 10 kilometer radius, or it has to go down to the 1 kilometer radius.
Yeah, got it.
Case they have.
Got it.
So that was the crux of the entire thing. So.
Yes, Mr. Burwa. I got it. You can take your seat.
I challenge this, my lord, this order. that
Your
is-
challenge to the order is 19/12/2024.
Yes, last order, my lord.
Hmm.
First is, my lord, this order was passed by violating the Supreme Court's judgment, my lord. The Supreme Court doesn't stay there, my lord.
Okay, take me through that order.
That is, my lordship, fine it. Page, next 21, page 187.
Hmm. What is the technical problem here? We'll come on merits. What is the technical problem first?
That impugn order, my lord.
Any jurisdiction problem here?
No, not reason, my lord, because it was heard by the, my lord, ADC, and order was passed by the, my lord.
Okay.
On that ground, my lord, and when the matter was, my lord, notice was issued on 6/2/2025. This order asked the, my lord, government to produce the record and file affidavit. It is, my lord, found in a final order dated 6/2/2025. And second is this, my lord, but prior to that, there is a division bench judgment is there, my lord. That division judgment said, my lord, before giving my lord permission, whether affect the surrounding land. We are the person, my lord, we are having the agricultural land, my lord, and this brick lane is going to be established, that, my lord, the adjacent land, that is the result, my lord.
The Bricklane is already existing and operating.
No, my lord. They have it in 2012 when consent to operate has been given, they have not been operating.
Still operating? Bricklane?
But this order,
Huh?
this order passing.
Okay. Because of 19/12/2020. No,
Please.
Mr. Bora, come in.
2012, consent to operate was given in 2012, my lord. Then I filed a writ application, my lord. There were several round.
So this 19/12/24 is an order passed.
After this order, my lord, they have operated. Prior to that, they have not operated.
Right. This order is in pursuance to directions passed by this court
Passed by this court.
in 2013. 28/10/2013. We can go through that once.
That judgment, my lord.
Hmm?
That
The relevant paragraph you can show me. Conclusions. Therein, you had taken all the pleas that you are taking now, that within the radius of that Popitora wildlife.
Taken, my lord.
Yes.
Then I've taken.
And what is the conclusion?
Kindly see that judgment, or kindly refer to that judgment, my lord. The lordship find it much. Page annexer 18, page 164, my lord. Relevant page, my lord, page 173. Before going to that, my relevant page, my lord, kindly turn to, my lord, page 170, my lord.
Yes, I'm
Page
there.
20. Start from, my lord.
Para 7.
Internal paragraph 7, my lord.
Ah.
Page 170.
Ah.
That is the judgment of the division bench. Has your lordship got it?
Yes, yes.
I have heard the learned counsel appearing on behalf of the parties and also peruse their materials on record. The material record, it transpired that the learned division bench of this court in its order dated 23 had recorded the consensus and the party in the said proceeding. The relevant paragraph of the order dated 23 regarding the consensus arrived amongst the party are reproduced here. First, the applicant respectfully submitted that the deputy commissioner may be directed to decide as to whether the Bhavani brick proprietor should be.
This is the brick clean of the private respondent.
Yes, ma'am. That's what.
Bhavani brick.
Well, my lord.
Proprietor is Dilip Chetri.
Please check, my lord.
Who is then Soikia? Who is Bharat Soikia?
The person, my lord,
Oh, you are the. Okay.
in this order,
Got it.
will be allowed to run and whether the same will affect the appellant surrounding land or the environment. The deputy commissioner Morigaon, while deciding the issue, shall take into consideration report of the pollution control board, agriculture officer and forest officer AFRIS, that the applicant respectfully submit that all the concerned official of the pollution control board, agriculture officer and forest officer should give their respective report disclosing the scientific of such report. That the applicant respectfully submit that the deputy commissioner Morigaon may be directed to decide the issue after hearing the appellant and the private respondent number 1 Dilip Shetty. The applicants respectfully submit that the deputy may be directed to decide the matter within. From the above quoted consensus arrived at amongst the party that the deputy commissioner Morigaon, presently the district commissioner Morigaon, directed to decide as to whether the brick lane is set up by the respondent 12 should be allowed to run and also to consider whether the same will affect the writ petitioner hearing in respect to their land on the environment. It was further recorded the deputy commissioner Morigaon, while deciding the issue, shall take into consideration the report of the pollution control board of some agriculture officer as well as the forest official. That it also recorded that concerned official of the pollution control board, agriculture officer and forest officer should be submit their respective report disclosing the scientific of their report. But the impugn order, my lord, that was passed on 19.
Okay, now you can come straight to Mr. Borua 173 para 13.
Yes, my lord.
Taking into account of the above this code disclosure instance read petition with a following observation and direction. The Pollution Control Board Assam is directed to submit a fresh report as regard to the response number 12 within a period of 4 weeks from today and not later than 23/10/21 before the District Commission hearing. Agriculture officer is also directed to submit a fresh report to the District Commissioner in respect to the land wherein the response number 12 Bricklin is established within 23/10/2024. It is also seen from the imperial order dated 19/2/2024, the report to the tribal officer, Morigan Revenue Circle, as well as the divisional forest officer already been submitted, and such there should be no further necessity of submission. The court directed the opponent receive the said report as above mentioned. The district shall fix a date for hearing and a petition. This court directed the petitioner and response 12 heard before issuing any order. District Commissioner Morigaon, if deemed necessary, may call concerned official for hearing and a decision. The entry access should be completed within so and so. Court direction is the heard by the deputy commissioner. But I made an appointment, it is heard by the ADC, and order has been passed by the DC. This is one of the branch of submission to say that impugn order, my lord. I made a categorical statement. And regarding them, they have been asked to file reply, my lord, to produce the record, my lord. Till now, government has not produced any record. And reason, my lord, when this matter is pending, my lord, there is a Godawaran case is there. That case, my lord, Supreme Court has said, my lord, till the finalization of the eco-sensitive zone, my lord, 10-kilometer radius should be declared as the eco-sensitive zone. And regarding that, forest also file affidavit, my lord, it is before your lordship, my lord, that forest say there, my lord, 10-kilometer is the eco-sensitive zone, and till then, my lord, it is there, my lord, there shall be no, my lord, any industrial activity. There is default eco-sensitive till that, because that eco-sensitive that has not been finalized. Even in spite of that order, my lord, this order consent to operate has been given.
What happened to the proceedings before the NGT?
That is still pending. That is still pending, my lord. That is still going on, still pending, my lord. And Learned Counsel, Mr. Bora is appearing that case on behalf of the Dilip State, the response 12, my lord.
What happened to the proceedings there, Mr.
There is also a case pending. And
That is in the Supreme Court.
therefore, now.
This is from the periphery of the Popitra Wildlife Sanctuary, or Popitra Reserve, wherever it is. How far it is situated?
No.
1 meters.
1 kilometer.
No, it is. That is a wrong submission. Wrong submission has been made, my lord. No, wrong. Wrong.
No restraint order from the NGT. No restraint order. Whether that was taken into account.
Forester.
Okay. So we only have to see whether the deputy commissioner had considered all the points on which such consideration was directed to made by this court in the last order.
Well, if there are judgment, if it filed with a forest, my lord, they categorically stated, my lord, it is 10 kilometers. But I see that they are affidavit. No industry like within the 10
We'll have it, we'll have it.
that one affidavit.
Your case, Mr. Mr. Burwa, is that one agriculture land, prime agriculture land, using that for bricklaying has the effect of harming the other villages who are also having agriculture activities therein or adjacent thereto. Second, the matter was heard by, after remand was heard by the additional deputy commissioner and the orders were passed by the deputy commissioner. Three, that the bricklaying is within 1 kilometer from the 1.1 to 1.2 kilometer from the Popitora Wildlife Forest.
Definitely, my lord, because it, my lord, meets of the Pavitra wildlife and the Rajama wildlife.
So either way, both the wildlife, it comes within the what do you call that, eco-sensitive zone of that wildlife.
Outer one, my lord, 1 kilometer. The meets, my lord, their proposal has, my lord, proposal that has been submitted 3 kilometer. And Brickley is, my lord, the meets of that.
Both.
Yes, my lord. Second is, my lord, this impunity, my lord, that what?
Where have you stated that the deputy commissioner did not hear the matter and the matter was heard by the para 38? What is your reply to para 38, Mr. Who is appearing for the state? Any affidavit filed? Not yet filed.
They asked to file a record, my lord. Then
Yes, Mr. Bhattakur. Notifications issued with regard to this 10-kilometer thing. Have notifications been issued?
Ministry of Environment.
Mr. Burwa, you have your say. Yes, notification issued.
Notification as of date, that is for, my lord, that default 10 size as per the.
How can it apply when you don't have a notification? If that notification is not there, what would be the distance? Godavaram. That with regard to the Assam Popitora, one line order, one line.
There are two orders, two.
Ten kilometers, that is it. Under circumstances, we direct the area of 10 kilometers. Declared as so and so. So after this, was any notification issued? Till date.
The boundary of the wildlife sanctuary itself, that is also pending adjudication. Notified, but that has been stayed, my lord. That order is also.
Pavitra.
So now the older boundary exists because that
It wanted, the re-notification had curtailed the area of.
they just wanted to denotify so that they could bring another notification for a different boundary. But that process has been halted by the Supreme Court. And is that some villages were included without consultation when
Okay. Who is appearing for the Deputy Commissioner? Mr. Roy. This court had remanded back the matter with certain directions for consideration in a particular manner. We'll consider Mr. Borua's plea that the Deputy Commissioner, the additional Deputy Commissioner heard, Deputy Commissioner passed the order. We'll hear it. We'll consider. But tell me, where is your conclusions with regard to this eco-sensitive zone? The Deputy Commissioner cannot have a view contrary to what the Forest Department can have. If the Forest Department stand is 10 kilometers, how can he say 1 kilometer? Where is that finding? (163), second paragraph. Second page of that order. Okay.
third last.
So, this is your letter. Why is your divisional officer writing this when you submit that it will be 10 kilometers? But what is your policy? Your policy in your affidavit, Perusal, is 10 kilometers. Show me your statement there. Affidavit filed by page 190. This is 1.2 kilometers. So was this report placed before the Deputy Commissioner? Page 192 and 198, 193. Where is this report of the Nagaon Divisional Forest Officer? No, this is by the Guwahati Wildlife Division. This is by the Guwahati Wildlife Division, not by Nagaon. What is considered in the report at page 187 is something from Nagaon. Okay, let us see one more thing. What is the date? 190? No, the date is also different. It's 30/12/23. It should be actually, if it is a division, it will be Morigaon. But this report is not considered here. What is this letter then? 30/12/2023, Mr. Roy, third paragraph from bottom. High Court order is dated 3/12. So thereafter, somebody had submitted a report on 30/12. And this report that you are relying upon, Mr. This is after the order. So this is the position 194, you say it's within 10 years, 10 kilometers, so it cannot be. Yes, Mr. Bora. All said and done, if the state concludes that it will be 10 kilometers, then the order passed by the deputy commissioner is erroneous. And he has not taken.
Ultimately, what it boils down to, what does T. N. Godabaram say about the boundary in case of mining? But secondly,
We will not go into those. Supreme Court saying that it should be 10 kilometers, it will be 10 kilometers.
no 2018 order was subsequently modified in 23.
Where is that modified?
Yes, Lordship, I have filed an affidavit, preliminary affidavit.
Where?
And annex the order at page 262.
262.
Some more documents I required to bring in, Lordship, which will further clarify the issue.
262.
Initially, it was 10 kilometers because nobody had sent the draft proposal. Thereafter, in 2022, there was an order from the Honorable Supreme Court making it from 10 to 1. In 2023, now this order comes. Sorry, Lordship, it's 162, Lordship.
That's the order starting. Where is the relevant portion?
Relevant portion at page para 28, Lordship, would find this order. Seven, Lordship.
That
The
is
next
where
rel-
this 10-kilometer thing had come in.
Yes, that 27, the first 10. Now, Lordship would see at para 60. I was just pointing out to show that this order was also considered. In so far as restriction on mining is concerned, we are of the considered view that it has that the mining activities within an area of 1 kilometer of the boundary of the protected area will be hazardous for wildlife. Though in the case of Goa Foundation, the said direction were issued, found that such direction need India basis. Therefore, declined to allow the present IA with a direction in paragraph order dated 3rd June 2022. Verify that a direction contained herein would not be applicable to ESG in respect of which draft notification or final by the MOEF CC and in respect of proposals which have been received by the ministry. Now at para 65, we also modify 56.4 of the order dated so and so and directed mining within the national park and wildlife sanctuary within an area of 1 kilometer from the boundary of national park and wildlife sanctuary.
Sorry, can't be accepted. That is mining. This is pollution. It will be 10 kilometers.
But mining Lordship.
And there were specific directions with regard to Bricklin by the Supreme Court. Where is that?
Falls under the category of mining.
Not mining, Mr. Show me.
The draft.
Where is that decision of the Supreme Court pertaining to Bricklins specifically? Whether it was within Govardhan Verman or Kaziranga? You have it? Show me, Mr. Bora, that this is also a mining.
Mining, yes. Lordship. Draft proposal is annexed.
It's a minor mineral.
Yes, Lordship, page 54. It's,
Of?
the writ petition.
Hmm. Hmm. 52. Huh. Hmm.
Commercial, 54, no.
Hmm.
For the chart is given,
Hmm.
commercial mining.
Hmm.
Regulation will not prohibit the digging of earth for construction. Provisions for.
This is not your activity. This has got no pollution. Your activity will lead to pollution, smoke.
Stone bearing and mining.
That is different. There is also nothing. That is why compensatory forestation is done. They have to make a mining plan. Show me your mining plan. Then I'll record your submission that a brick lane is a mine and you have not been able to show a mining plan. So in view of the minor minerals rules, stopped. We are stopping it. This will not be allowed to continue.
After.
And Mr. Purva, what is this? What are you doing as a pollution control board? Ignoring the directions in Godavarman and then permitting the operation within a one, you permit an operation of a brick lane somewhere, I'm not.
There is bricklaying rules also, Lordship.
Now, how can you? That has not been done. Not been formulated. It's not. But Mr. Chod, very surprising. Where is your report? Give me a report. Have you taken this case of Godavarman into consideration in your report?
Was not.
Why?
because
Why?
ultimately It was only debated upon the parameters and the discussions. Yes, because the distance criteria has been found out by the circle officer's report. So that if your lordship goes to paragraph 4 of the report that we have.
Give me a second. So, Mr. Burwa, you also agree in your report that it is 1.2 kilometer or maximum 2.1 kilometer, right? Now, if it is that, Godavarman is there, staring on the face of it, your face, 10 kilometers. That's the pronunciation of the Supreme Court, 141. So, why that was not factored? And that is exactly what this court required to be factored in. You have not factored that in. Why this rush? There was a rush. There was a rush.
It's a joint.
What is the date of this report?
Finally,
What is the date of this report?
that I feel to
Forwarding letter is 23/10/2024. Order of this court is 27/9/2024. Where is your
because it is with regard
inspection report? Where is your inspection report? Where is the report? Where is your inspection report? Pollution Control Board. Where is the annexure to this? Fine. But what about the Godavarman thing?
Distance criteria. So that has to be decided by. Was under the parameters. We are only deciding upon.
And Mr.
fair
Chaudhary,
policy.
Mr. Borua, when you say that there is no human habitation nearby, right? Fine, there may not be human habitation. But the land wherein this is done, it's not a barren land. It's an agricultural land. And bricklins are normally set up in agricultural lands. Where is your report with regard to the effect the bricklin would have on the land, soil, water? Why?
Agriculture department.
No, you will have to do it. Pollution. You are only air pollution. There is no other pollution from a bricklin industry.
Air is the primary pollution.
Primary. What would happen to the sediments?
No, that's what.
What would
that's
happen to
what-
the sediments?
That's what. So we have adapted to the new. That is zigzag technology. In the particular towns, instead of flying and just emitting smokes. So this is the technology which has.
So he is Mr. Bora is having a
Yes,
zigzag
yes,
technology.
That we have explained in paragraph 6 of our report. So it makes it very clear as regard the emission particular matter which are emitted into the air that has been restricted by this new adoption of the technology.
So you still have
And
248 milligram emission, particulate matter
yes,
coming
yes,
out.
yes, yes,
And that is settling in the food crops.
yes, down because it
No, 248 is what is coming out.
coming up.
So where is this coming out going to? It will go to the food grains only.
Also very well knows that bricklin are established in lands which has been converted from agriculture to industry, saying that those are barren lands. Finally, it is business prerogative whether they make cultivation or not, because it is the authority who decides whether it's. Because our spare is only limited after all those windows are being cleared, they come and just settle final note of the consent.
Mr. Bhattakur, give me your DFO Nagaon's 30 12 23. You can also give me that. Huh?
Entire documents of the petitioner arise from SDR environmentalist. The earlier round, 4604, there is at page 55 and 116 of the earlier round, there are 10 other bricklins. There was an affidavit from the forest department also that 10 bricklins are running, but the petitioners are only affected by this. They are not a single statement that they have their patta land or something agricultural land.
They say they have agricultural land.
But no document to that effect has been produced. If they are environmentalists, they have assumed locus on that point. There are 10 other bricklins closer to me, which they are not affected by. That was on record in the earlier proceedings, Lordship.
So, Borua, when there is a reserve forest or be that as it may, any forest wherein an eco-sensitive zone should surround it. Will a zigzag technology be permissible within that eco-sensitive zone?
It ought to have been.
I'm not on that. Whether this zigzag thing will come also validate a bricklin set up within that halo of that eco-sensitive zone, or is it something that is permissible outside that eco-sensitive zone? Gone. So
Developmental
your report says 1.2 or 2.13. We'll have a clarification from Mr. Bothak. If the policy of the government is 10 kilometer, right? Then your report itself enough to hold that the bricklin is not operable, because it's within the eco-sensitive zone.
That we are guided by the documents that
That's it. Get me those 3 reports.
the deputy commissioners finding in this respect, because the circular substantiating the fact that
Because we have one report here in the affidavit which says it should be 10 kilometers. But before the deputy commissioner, it seems that Morigaon and Nagaon DFOs had filed some reports. We exactly don't know what it is. Let us get our hands on that. Mr. Roy, Mr. Bothakur. At the Lanark Council. Sir, we have got it. We'll see what it is.
Regarding the violation of Supreme Court order, the Supreme Court has constituted a committee on 5/9/2023 by a statutory notice saying that
I'm a puny judge of the Guwahati High Court, and that too at the bottom of the rung. Why should I take on the Supreme Court? Whatever Supreme Court says is law, even more than the what it's mentioned in 141. So please don't bring all those things. Yes, right, Lika. Heard Mr. R. Borua, Lanark Council for the petitioner. Also heard Mr. I. Bothakur, Lanark Standing Council, Forest Department, appearing for the respond number 1, 2, 6, 7. Six and 7. Also heard Mr. S.S. Roy, Lanark Government Advocate, appearing for the respond number 3, 4, 5 and 6. 5 is you are not there. 3 and 4. Also, Mr. S. Borua, Lanark Standing Council, Pollution Control Board, appears for the respondents number 8, 9, 10. Also, Mr. B. Bora, Lanark Council, represents respondent number 12. Also, the matter was heard at length. During the deliberations so held, this court desires to peruse the reports submitted by the Divisional Forest Officer, Nagaon, on dated 30/12/2023, before the District Commissioner Morigaon, and recorded in the order dated, impugn order dated 19/12/2026. Also, the report that is also submitted by the Divisional Forest Officer Morigaon be also placed on record on the next date of listing by Mr. I. Bothakur and also by Mr. S.S. Roy, Lanark Council for the District Commissioner. Also, Mr. Bothakur on the next date of listing shall clarify the stand of the Forest Department as to the area which would now form a eco-sensitive zone from the periphery of Popitora. It's a reserve forest, wildlife sanctuary. Also, the said instructions and the documents be placed, said instructions be placed on this court in writing from a competent officer of the department. Also, the other issues raised by Mr. Borua is kept open for further consideration on the next date of listing. Registry to list this matter again on Kundina Pari. 18 সপ্তাহ তাৰ পিছৰ সপ্তাহটো দিওঁ 26 সপ্তাহ 28 মঙ্গলবাৰে নোৱাৰি 27 বা 29 right 28 or 28 Thursday 28 8 2025 you get these things we'll see Mr. I'm not closing I just want to understand because now one thing is fixed you are within 1.2 or 2.1 so if it is 10 we need not go into anything that is the end of the matter that you get me and if it is mining along with your mining plan minor minerals require a mining plan CR clearance pollution control board cannot give if there is no CR clearance so be careful
earlier when DFO has submitted that report state where it is in the midst of the Rajamayang and Povitra Mayang.
that's what we want to clarify because the
Parties also no not
I've written
the boundary in the midst of the between the two forests.
fine if not this then that somebody is covering this area so let us see he is also having a livelihood we don't want to interfere very casually
No, we also live 2012 my lord. Fight.
no your livelihood Mr. Borua says is safe Mr. Pollution Control Board says it's very safe
Earlier agriculture report said my lord if
have you got any report from the soil report of any pollution
no agriculture report
no Mr. Borua have you got any report of this from the soil adjacent to this clean saying that because of the particulates falling there is poisoning have you or the food that is the crops that are growing there have particulate material which is a result of this clean get me those reports we'll see just filing a writ petition is very easy making you if you're making that submission please get me these reports also otherwise we are not accepting that it's on a technicality only on that eco-sensitive zone thing Mr. Bodhagur see what which one
Regarding whether it is an
that is a deliberation between me and Mr. Borua Iman? Yes Mr.
if they are
No, I am liking GST matters. No reply is required, madam. Why today, not today?
Lordship, the arguing council was supposed to appear virtually, but due to difficulties.
Today, the permission was granted. I was expecting an argument. Miss
We put that.
P. Podda, Learned Counsel for the petitioner, prays for an adjournment in the matter in view of on the ground that the arguing counsel could not attend the program, could not attend the hearing online today on account of certain technical issues. Also, prayer is not objected to by Mr. S.C. Kail, Learned Counsel for the petitioner. Registry to list these matters again after. Registry to list this matter again in the month of September on a date to be fixed by it. We have fixed the date today. Last date on your prayer. Nobody is here. Registry to list this matter again September on 16/9/2025.
26 August, Your Lordship.
16/9. Yes, Mr. Todi.
Lordship, challenging the impugnation order.
No affidavit.
properties involved in this case.
challenge the jurisdiction of authority. Points lordship. He has exercised power under section 74. Can be exercised only in case of fraud or misrepresentation. X. Here there is no finding by the assessing authority fraud or misrepresentation. Plus also on the point that he has clubbed the multiple assessors in one assessment order, which is not permissible. On the line lordship,
There are some decisions of our High Court also on that.
not on clubbing.
Jurisdiction?
On jurisdiction of exercise of 73 and 74 is there by the honorable bench of Justice, which I'll be relying for this case. For clubbing of assessment years. are
Yes, what do you
concerned-
say on this?
Of,
Any decision of the Supreme Court on that?
Supreme Court.
But our High Court, nothing. So we'll have to consider those Madras and Delhi. Can you give me copies here? The copies relevant. But today it may not be possible. So when do you want it? Last week board decision. Kima, 28. As agreed to by the Learned Council for the parties, registered to list this matter on 28/8/2020. When? Huh? After? 28 times.
Lordship will provide it.
You can, then it will be there, then it will be better for me to
I'll provide today itself.
learn and come.
By today itself, Lordship. Much of.
Mr. The Delhi High Court also you give it.
Here petitioner is also.
But Mr. Todi, this is the order by the assessing officer. There is a power of appeal.
Yes, sir.
Is a power of appeal, Lordship, but
If that issue is still in a fluid stage, whether the clubbing can or cannot be. So if we follow Delhi, you will have to go up for an appeal. If we follow Madras, maybe division bench. It was a single judge order. And
the
Delhi,
division bench has allowed.
Delhi is division bench. Get me? We'll see. That initial fear with tax matters is going now.
Case, the petitioner Anish Shah up to the location, same district. It is permissible.
Pending before the committee.
Wait. You should not have. You should take a call.
Already decided the issue, my lord. Honorable Court has already decided the issue, my lord. At page 33, my lord. 10%, my lord, page paragraph 10 to.
But your application has not been rejected till now.
My application has not been rejected. They are not acting on that. I am paying the revenue.
Of that. You have not been able to operate now.
Operate. I could not.
Where is that Excise Act? Excise Act. Is it note on to?
Amendment provision.
294.
I have annexed the amendment provision is 28.
No, it's 294. Commissioner, Excise Commissioner, or the District Collector, both are given power. This is Commissioner, Excise Commissioner is the Commissioner of Excise.
Commissioner has to do.
Where is that?
163A.
Shall both have to take the consent from the state government, be it the Excise Commissioner or the District Collector. Both have to take. You are within the same district. No dispute on that. Okay. Where is the fax from where I can get it? No affidavit required from you. No, petitioner states they participated in a e-tendering process and declared H1 bidder. Was there no specific location in the tender?
Yes, dear my lord.
That tender location you are not being able to. So you wanted to change it to
Right to Lanka, my lord.
Lanka Town Kisam in the house of Rumi Sil, right? 2 lakhs deposited. Who is respond number 3?
No, he is the Malad.
District Commissioner.
He has the renewal fees also, my lord.
Heard, Mr. We are disposing and directing the commissioner to take a call. Heard Mr. Ayat Saikia, Lanat Council for the petitioner. Also heard Mr. I. Bhattakur, Lanat Standing Council, Excise Department appearing for the respond number 1 and 2. 4. 3. Mr. DJ Talukdar, Lanat Senior Council appears for the respond number 3. The grievance raised in the present proceeding is to the inaction on the part of the respondent number 2 in permitting the petitioner to shift his India-made foreign liquor, bracketed IMFL, bracket over, retail off-shop premises, off-shop, namely Messrs. Golden Globet from NSCB Road, Krishna Nagar, Ward number 9, Huzai District, to Lanka Town Kisam, Lanka, District Huzai, on the premises of, on the rendered premises of Srimati Rumi Sheel. So, the petitioner herein, in pursuance to an e-tendering process, was granted IMFL apostrophe de off to apoduta apostrophe off license at NSB Road, Krishna Nagar, Ward number so and so. The license so authorized to the license so issued to the petitioner bore number 1/24-2025. It is contended by the petitioner that he had developed the premises for starting his operation, and the shop was named Messrs. Golden Globet. However, while the petitioner was in the process of establishing the IMFL apostrophe of shop, comma, the local people, the residents of the locality tested to the setting up of a wine shop in their area, and accordingly, the petitioner could not start his operations therefrom. The petitioner informed the matter to the departmental officials, and it is contended that a survey of the shop, that a verification of the reason given by the petitioner for not operating his shop was also done. Also, as the license of the petitioner was not being made operationalized with the opening of the said shop, the petitioner submitted a application before the district commissioner, Uzai, for seeking transfer of his shifting of his existing IMFL off shop to Lonka Town, Ward number 7, Lonka Town, Kisamat, District Lonka, and to District Hojai, and to set the same up on the rented premises of one Rumi Shil. So the petitioner for the said purpose had also enclosed, along with the said application, a tenancy agreement entered into between the petitioner and said Rumi Shil. It is projected in the petition that the said application of the petitioner was recommended favorably by the jurisdictional inspector of excise. The said application recommended full stop. On the submission of the said application by the petitioner for shifting to Lanka Town, a verification as mandated under the provisions of the Assam Excise Act was carried out in the matter by the Inspector of Excise, Lanka Circle. On the conclusion of the verification process, the said authority recommended the shifting of the petitioner's IMFL shop to Lanka Town wide, recommended the shifting of the IMFL shop of the petitioner, to the Deputy Superintendent of Excise, Lumni, wide, communication dated 18/12/2025. Also, thereafter, the district commissioner, office of the district commissioner, forwarded the proposal of shifting of the premises of the IMFL of premises of the petitioner to Lanka to the Commissioner of Excise, Assam, wide, communication dated 26/12/2024. Also, along with all requisite reports and checklists. Also, the petitioner submits that in spite of the said developments taking place and the matter being placed being forwarded to the Commissioner of Excise, Assam, on 26/12/2024 by the Office of the District Commissioner, by the Office of the Jurisdictional District Commissioner, no decision has been taken thereon till date by the Excise Commissioner. The petitioner submits that he is required to now bear the cost, the rent of the premises now taken on lease by him, as well as maintain the premises against which his original license was so issued. The petitioner has further projected that he has already deposited an amount of rupees 3 lakhs before the excise authorities for the purpose of consideration of his application as fees for the purpose of consideration of his application for 2 lakhs. And 1 lakh is for?
3 lakhs is for renewal.
Okay, 2 lakhs for the purpose of consideration of his application for shifting. Full stop. The petitioner also contends that a further amount of rupees 3 lakhs has also been deposited by him for the purpose of renewal of his license, although the petitioner has not been able to earn any income in pursuance to the issuance of the said license. Full stop. Accordingly, he submits that an appropriate direction be issued to the excise authorities for permitting the petitioner to shift his IMFL off premises to Lanka town. Also, Mr. I. Bhattakur, Learned Counsel for the petitioner, while fairly submits that the petitioner, although was issued with a license for opening IMFL off shop at Huzai, he was prevented from opening the same on account of protest from the residents of the area. Also, it is submitted that the excise authorities had forwarded the matter to the Commissioner of Excise had forwarded the proposal for shifting of the IMFL shop of the petitioner to the Commissioner Excise by complying with all the requisite procedure mandated in this connection. However, the decision thereon is still pending on the part of the Commissioner of Excise, Assam. Also, the Learned Council also, I've heard the submissions of the Learned Council for the parties and also perused the materials available on record. To me, para 9, 10, 11, page 36, 37. 12 next to my DSO to my 12 TRS to 12 my DSO to likhilo. In the present case, admittedly, the petitioner, after being granted the IMFL retail off-shop license for opening a shop at Huzai, has not been able to open the said shop on account of the protest raised in the matter by the residents of the locality. Also, the petitioner, having taken a premises on lease at Lanka and thereafter submitted his application for shifting of his shop from Huzai to Lanka, comma, the same being within the district of Huzai, comma, such shifting being permissible under the provisions of Rule 294A of the Excise Act,
Rules, my lord.
Excise Rules, Assam Excise Rules 2016, comma, this court is of the considered view that such application which has now been placed before the Commissioner of Excise Assam in a form of a proposal by the Office of the Jurisdictional District Commissioner must receive its due consideration. Also, in view of the above discussion, the Commissioner of Excise, Government of Assam, is directed to consider the proposal submitted by the Office of the Jurisdictional Deputy Commissioner for shifting of the IMFL shop of the petitioner in accordance with the stipulations contained in Rule 290, I go to section Rule 294A of the Assam Excise Rules 2016. Within a period of 15 days from the date of receipt of a certified copy of this order along with a representation from the petitioner herein. Also, with the above observations and directions, the present writ petition stands disposed of. Some corrections required, but I'll just make those. But tomorrow we are leaving by 1. I'm not sure whether you'll get these orders on Monday only.
I will stay, Lordship. Lordship, pass over the matter for that.
For the
day, Lordship.
For the day. What is the matter? What is the matter?
The petitioner sold a plot of land measuring 1 kata 9 less.
That we can all read. Tell me. Have you read the brief? Why? How long have you been in practice? 5 years. I've still not read the brief. Or you can read the brief only by like this. Brief ready. Why have you not read the brief? You are expected to read the brief. Next time, please don't appear. Read the brief, at least the facts you must tell me. Huh? On the prayer of the Learned Counsel for the petitioner, registered to list these matters again. Any objection, Mr. Oh, where is, what happened to you? Have you made an application on the Seva Hetu?
As per last order, instruction was awaited, Lordship.
Instruction. On the prayer of the Learned Counsel for the petitioner, registered to list this matter again on 19/8/2025. On the next date of listing, the petitioner shall apprise this court with regard to the query raised to the petitioner wide the order dated 4/8/2025.
Maternal death case, Your Lordship.
Huh? I didn't get you.
This is maternal death case, Your Lordship. Because, the arguing counsel she was here in the morning and.
No, she was here. I've seen her. Okay. A prayer is made on behalf of Miss M.S. D. Ghosh for an accommodation in the matter on account of certain personal inconvenience. Prayer is not objected to by Mr. M. Bhuya, Learned Standing Counsel, Health and Family Welfare Department. Registry accordingly to list those matters again after 2 weeks on a date to fix it. একো থাকি যোৱা নাই চবটো হৈ গৈছে ইয়াতে ডিসপোজ হৈ মেম্বাৰ ডিক্টেশ্যন
The minutes of meeting.
petitioner was also there.
Yes,
Lord,
Lord.
that page your lordship will find.
Kabir Ahmed at serial number 5 is
Yes,
somebody
yes,
else.
He was, at that time, he was there.
He was
Uh,
there.
Before all this happening.
I was there, but on that day, Lordship, meeting was not concluded. Subsequently, they have taken that resolution. I have stated in paragraph 8 in my writ petition.
Everybody has a grievance and we are here to hear. So, Doctor,
I understand. Milord. Lordship may see the page 5, the new.
just a
comment.
moment, just a moment. Where is the date in the first page? It's not there.
That will, Lord, on the top, right-hand side.
16/6.
16/6.
So that is the first day of this meeting. And then that
No,
meeting was not concluded or it was concluded.
Is concluded.
Last meeting.
And thereafter,
Who is the,
Just a moment, Mr. Khan.
Hello.
These documents you have.
resolution? No.
Huh? Then take your seat. Then take your seat. Yes, then what is this 2412?
and 2412 is the committee that your lordship will find at 5B.
This is the meeting of the committee constituted on 16.
Yes.
We are not concerned. That is different. I only want this. And what about that continuation of that gentleman who had filed an affidavit in support of the petitioner here? When did he go move out?
That your lordship will find. Your lordship kindly see page 5.
Hmm. New committee which was set up on 16th.
Yes,
In the committee of 16, his name figures.
yes.
Then,
After that new committee, your lordship may see
hmm,
this meeting, your lordship will find 2412. Yeah, meeting of the.
no, we got it. How do I get it that he is not there?
Yes, that from the list your lordship, will-
His signature is not there.
yes, from
And he had never participated thereafter.
never he participated. From 1 to 15, your lordship.
Now, how did the deputy commissioner issue that order subsequently constituting the managing committee? No, after 16/6, there is a order, there is a notification by the deputy commissioner. Under what authority he had issued it?
16/6, he did not do anything, my lord.
No, he did. On 4/7, he issued a notification.
That was the last,
That is it. Insofar as 21/3 is concerned,
just one.
72. Four eight three three. We are at page 72. I think it's your affidavit. It's your affidavit. 72.
72, yes.
So this 72 minutes we have. 14/2/23 we have. Therein there is a request to the deputy commissioner to do the needful. So he accordingly he notified this. Then we have next page 73. 07/2023.
Notification date.
That is in pursuance to 16. Where is that request? Similar request here. No, this is 14/2.
14.
No problem. 14/2 ended in page 72. Then you have 16/6, right? 16/6 minutes you have placed before me today. There is nothing here.
Tired of the
No. In this meeting of '16, the House entrusted, just down below, page 74, 1. To constitute an ad hoc managing committee among the members present in the meeting for the purpose so and so. So he notified. And here why did he notify? 16/6, why did he notify? Why did he notify?
earlier see. My lord, your lordship. Then, Society Registration Act.
No, that is a different thing altogether.
That your lordship has seen at page.
No, my thing is, why did he issue this 4/7/2023? No, that is the managing committee, ad hoc managing committee. 72, it was given to him, you constitute. So he notified. But this one, nobody gave him. Why did he constitute? I want a reply to that. Page 73. This notification. Constitution, we are not concerned. But this notification, why did he do? He is constituting. Who is he to constitute?
Problem is here, he has written DC. Have been DC
DC cannot be the president. And he is using a Ashok Stamba for that.
Because paired your lordship kindly see. Ought not to have done all these things. If all these things is not.
Okay. Yes, Mr. I got it. Yes.
That is the only point, lordship, regarding.
That is the only thing.
Challenging that notification, lordship.
So if this challenge, Mr. Just to understand, old chip, if I reject this challenge, everything falls through.
Yes.
Then now, Somin.
But in the second case, we have challenged the termination order.
That is gone.
Only because this.
Because of this.
Legal committee has taken a.
If the committee is legal, that termination thing also becomes legal, subject to you taking any action other than a writ petition.
Lordship, that you given a liberty court in that case. But so far this case, lordship, is 233.
If I allow you this first case,
Yes.
that automatically gets allowed because that action becomes bad.
Yes, that's why, lordship, we approach the lordship subsequent second case. Otherwise, I could not have come against the termination. It will be the appropriate court of civil court. Now only because this is the illegal committee, that committee has taken a decision, so decision is illegal.
So that committee that was constituted on 16/6/2023, you were also there in that meeting as a member.
I was there, lordship. I have stated paragraph 8 in my report.
Forget your paragraph 8. That is a development of Mr. M. Khan.
Development, Lordship, it was, in my first case, I have stated.
that is a development of the advocate filing the case. But on 16/6, when you appeared in the committee, 17 you did not have a problem. 18 you did not have a problem. You did not have a problem even on 7/4 when the 4/7 when the notification by the deputy commissioner was issued. You had a problem only when the suspension and the show causes were issued to you. Till that time, the decision of 16/6/2023, you had no issue.
But Lordship, while the district commissioner has taken that decision, Lordship, in the adoption of the.
There is
ad hoc
no
committee,
decision of the deputy commissioner.
in
That
the-
is what we wanted
I
out from. We have
constituted
got it.
the ad hoc committee in 21-3, Lordship. Is that consensus before the total violation, if your Lordship will come page 73, that only advocates and
445.
advocates and ex-minister MLA, these are those persons are the member in this committee. Yes, Lordship,
Can't help it.
I am not on that.
If
I-
a challenge to that
is-
comes, if the challenge to that comes from a concerned citizen, we may consider, but not,
Why not? Yes.
not from you.
Although that irregularity is that, I am not concerned on that. I am concerned only with the power of
The
the.
allegation against you is very serious.
That may be, Lordship, that will take its own course.
That has already taken its own course.
Yes, already has.
That is already taken its course.
Yes.
Okay. Today will not be possible to pass orders. We'll have to rise. And tomorrow also it's because we'll not be here after first. After 11th, we'll pass this order. Mr. Khan, I'm sorry. We are rejecting your first petition and the second one will go in the line of St. Mary's School, Supreme Court decision. What we wanted was whether the committee was a forced one from the deputy commissioner. That was the only apprehension. 16/6, your presence, that committee was constituted by the persons other than the deputy commissioner is nowhere there.
Their presence in the meeting does not give any power to the deputy.
Where is your protest? Deputy commissioner has not notified, has not constituted. He has only notified.
Notify-
That is a mistake.
That
That is a mistake.
He has constituted the committee.
Keep that point ready for your next round.
My lord, my paragraph 8 in my first petition, I have stated clearly.
Heard
It was
Mr.
happened
M.
in the-
Khan, Lanak Council for the petitioner. Also heard Mr. S. Dr. Lanak Senior Council and Mr. Huh? Just write it down. Just write down your parties. Luluba. Lululehu. Mr. Doctor, you will be assisted by S. Musahari, Lanak Council for the respondents number 5, 7, 8 and 9. Pakihini Luluba. Hearing concluded. Raised it to list this matter again on Kundina Pari. 19/8/2025. If you have a copy, you can give it.
Delivery of order.
Because I remember this case because I appeared for the Tezpur Law College. Similar issue. That was a disciplinary proceeding. And that judgment just came a few months prior to that. Okay.
Not for a delivery of order. it will-
There is no.
Lordship. Matter may also kindly pass for the day, Your Honor.
Due to paucity of time, the matter could not be taken up. Raised it to list this matter again on 21/8/2025 for further hearing.
23 to 25.
May I pray, your Lordship may kindly have a look to the last order, 24/7 to. Or then on 21st, Lordship, 21st August. 2015 matter. As a precarious situation.
Huh? Due to paucity of time, the matter could not be taken up.
Interim
Raised it to list those matters again.
on 21/8.
Sorry,
Then
2/9/2025.
29, not, then it is 49.
4/9/2025.
Interim order passed earlier.
Not continued.
Lordship, who will be hard pressed? Everything will go. Interim order
Interim order
passed earlier,
passed earlier
all
to
the three,
continue
date
till
petitions
the
needed.
next date of listing. In all the three, there are interim orders.
Interim order.
Report লিখি দিবা। একেলগে মাৰি দিবা।
On 49,
4/9/49.
all right, Lordship. Early solution should be there.
Yes.
National Highway Act.
That order. Yes, you are appearing for? Mr. Mahmood.
Well.
You have done it. Because now this case cannot be under 226, it should be under 227. You've done it. When? No slot for week commencing on 18, 11 and 18th. 26 or part 2, 26 I can fix it. Or 28. 28 at board division. 28. Due to paucity of time, the matter could not be taken up. Raised it to list this matter again on 28. 8/23.
Or to 12. Actually, this rate petition is not maintainable in view of the final judgment. That is the they have preferred at this stage that the judgment given by the
What is the remedy after that judgment?
so there is the appellate. Oh, my lord, at first, at best, they can
This is under 226. Yes, what happened to the proposal for constitution of a? We have kept this petition, Mr. Counsel, for only to know what is happening with regard to the appellate tribunal. Going on, it's going on for last.
I am making that submission. Code has to be
It will be a bench of 3 persons.
special.
With the district judge.
It is retired district judge, then my lord, that person member who is a judicial member.
This is not although they designated, he's designated as the special judge, land grabbing, but he's not there as a district judge. He's there under a statute.
Bank will
There is an appellate forum there.
try to resolve it. They are now taking the same.
How long do you think it will take?
Four repetitions pending.
I know that.
Right from the very beginning.
But there are orders. Special tribunal. Appellate forum has not been constituted in the manner required. Due to paucity of time, the matter could not be taken up today. Also, as prayed for by Mr. R. Borpujari, Learned Standing Council, Revenue, registered to list this matter again after 4 weeks on a date to be fixed by it. Mr.
L. Deca on behalf of M.
L. Deca, Learned Council for the petitioner, and Mr. A.K. Jain, Learned Council, appearing for the respondent number 4 to 12 is present. Mr. Jain, we appreciate that contention of yours, but our intention here was not for this case, but a general thing. I've been constantly pursuing the matter with the respondents, that let the appellate tribunal be created, because that would be required, because the statute says so. Why should we come in this stage? If not, nothing is happening, we will take a call in this matter.
In all possibility.
I know that. Now what you have said today, that is the main. If that is resolved, everything will fall. It's in good hands. Let's see it happens fast.